On item number 52, supply motion. We have received the leave encashment, my lord. I beg to withdraw the writ petition. With file because we have not received the leave encashment. In the interregnum, we have received the leave encashment.
You have received the
Received the
what?
leave encashment for the 300 days.
Mr. S. Bonig, the learned counsel appearing on behalf of the petitioner submits
On instruction.
that the petitioner have received the leave encashment, and as such, there is no live issue in the instant writ petition. Taking into account the above, the writ petition therefore stands closed as infructuous.
Grateful, my lord.
Interim orders, if any, stands vacated.
May I please? Lordship, I'd like to mention and place before your attention for urgent listing of a transfer matter of a 28-year-old girl who has been transferred while on leave to look after her ailing mother. This is an illegal and malified transfer. So I would request for a urgent listing of it.
Today,
Today.
May
Much.
please, your lordship. My lord, I may be allowed to move my urgent writ petition tomorrow, my lord. The highly.
To mention for listing of a suspension matter.
Hmm?
I beg to mention for listing of a regarding suspension matter. Maybe tomorrow or
motion,
no, that would.
admission will go on 4th of February.
Okay.
May I please your lordship? Lordship, I pray for listing of a writ petition. It was last listed on 4/2024, lordship, in the month of April, lordship.
What is the matter about?
Matter about IA, lordship. In IA, we have some changes in the name, lordship.
Hmm?
Lordship, IA has been filed for change of the name, lordship. Actually, some mistake was there. That's why we have filed an IA, lordship.
4th of
Much
February.
obliged, lord.
I beg to mention item number 1 and supply item 58, lordship.
Why?
Kindly consider the matter for the day, lordship.
1 and
1, 58 supply.
why 1?
Today is some difficulty, lordship.
What is the difficulty? Because last time I adjourned this matter. It came up last time. No adjournment. Next. 58, okay, adjourned it. There's no interim order. Is there any interim order in 58?
Because of the incomplete preparation, lordship.
Hmm? We'll see when the matter reaches. Next.
Maybe I beg for listing a petition, lordship, in admission column, lordship. Admission column, lordship.
Okay, 6th of February.
Can I
May it please, your lordship.
fourth, okay. Can I do fourth, lordship? Obvious.
May it please, your lordship, my lords. Beg to mention for listing of a writ petition for orders, my lords. Can even 28, my lord.
What orders?
My lords, the petitioner has been awarded compulsory retirement, my lords, without being heard, my lords.
Orders?
Yes, my lords.
What is the order for? What order do you want?
My lords, the matter has not been.
Find
listed
it
yet,
out
my lords.
and then mention later on, next date, tomorrow.
May I please, your lordship?
Yes, ma'am.
I beg to mention for writ petition civil number 3434-2025. Inaya Malakar versus Union of India. I beg to list this matter, lordship, next week.
Why?
Urgent. Why it's urgent? The matter is urgent because the mother of the petitioner is facing financial difficulties, lordship. As the death cum retail benefits are still in the custody of Railway Authority, and they are denying to release that until and unless the honorable court passes any order, lordship.
4th of February.
4th of
February.
Maybe,
lordship.
may it please your lordship. Your lordship, I beg to mention for listing of a writ petition regarding promotion to the post of principal in a secondary school.
Huh?
Secondary school. Principal, sorry, principal.
Principal.
Even the beginning item number 4600. 46, your lordship.
Item number?
46. I am here for correction. My place may be taken at 2 p.m. because
What is the urgency?
I have some personal problem. I have some personal problem. I have to,
46, IA.
I,
What is this IA business? I,
And actually, it should be the village name is different mention, or not, other things are okay.
okay, we'll see.
That to be okay.
May it please your lordship, I beg to mention for adjournment item number 17, motion, your lordship. In this case, certain circumstances have evolved after we have filed, your lordship. And today the petitioners have been called before the office of the social welfare department. So once that meeting goes by, we would come to know about the other part of the case, your lordship. Kindly adjourn for today, any date on the last week of January or first week of February, your lordship.
Item number 17.
Item number 17, motion, your
At
lordship.
the request of the learned counsel for the petitioner, matter stands adjourned to be listed again on 9th of February.
You're blessed, your lordship.
Lordship, I beg to mention for listing of a petition for motion, Lordship, on 28, Lordship. Fresh motion, Lordship. Obliged, Lordship.
May I please, your lordship, we have filed an affidavit in item number 43, which may kindly be called for. Item number 43.
Okay.
Obliged, your lordship.
May I please, your Lordship, I beg to mention for listing WPC 765/2025, petition for listing on 29th.
Why?
The area salaries of the petitioner is under challenge
30.
30.
30.
One more.
Huh?
One
One more. Okay.
29,
30.
30. Obliged.
For motion item 1.
May I please, your Lordship, kindly pass over the matter for timing, Lordship.
What is the instructions?
Instruction is, my lord, that already charge sheet has been filed against the petitioner, my lord. There was an FIR. Then charge sheet is filed. So they are basically, my lord, home guards. They have been released.
No, the question is whether have you suspended him?
My lord, home guard, so they are not regular employees, my lord. So question of suspension doesn't arise, my lord. They are not covered by
So
disciplinary
you have
appeal rules.
released him.
Release. These are voluntary, my lord, my lord, appointments. Basically, home guards are volunteers.
Have you intimated him? Have you intimated him?
My lord, that part,
You don't release him like this, no? Can you release him like this?
my lord, in this case, my lord, issue notice, then I will file an affidavit.
Better off. Because you can't release him unless by some order. And if that is so, he can challenge it.
Yes, yes. For releasing even, some order has to be passed.
Some order. You cannot say on the basis thereof.
That is the mal. That release order has to be communicated, mal.
Issue notice making it returnable on 6th of February 2026. Mr. Ardhor accepts notice on behalf of respondent numbers 1 to all the respondents.
It will be all, my lord.
Accepts notice on behalf of all the respondents.
1 to 6, all, my lord.
Extra copies of the writ petition be served upon him during the course of the day. The grievance of the petitioner herein is that the petitioner has been placed on suspension verbally in the year 2024 itself Full stop. It is seen with effect from 31/3/2024. So it is seen from the records that by an order dated 26/6/2025, this court sought for instructions from the counsel appearing on behalf of the respondents.
My lord, may I'm interfering, my lord. My lord, there is an order I have just found, and to person concerned, it is marked.
Madam, you do one thing. We close the writ petition with the liberty given to you to challenge this order of 4th of April.
And what the matter for timing, Lordship?
Time being? What time being? I'm giving you this because without a challenge to this order, you cannot succeed. You are carrying on a matter from 2025 June. No, every time you are asking for time. Now, heard Miss So-and-so appearing on behalf of the petitioner and Mr. Ardhar, who appears on behalf of all the respondents. The petitioner herein is aggrieved by the verbal suspension with effect from 31/3/2024, and as such has approached this court by filing their present writ petition. The record reveals that the writ petition was filed on 8/5/2025. This court, by an order dated 26/6/2025, was not inclined to issue notice, but however sought for instructions from the respondents as to why the petitioner was put under verbal suspension with effect from 31/3/2024. Today, when the matter is being taken up, Mr. Ardhar, the learned counsel appearing on behalf of the respondent, submitted that in view of the involvement of the petitioner in respect to Gorchuk PS case number 98/2024 registered under section 387/506/34 of the Indian Penal Code, the petitioner was discharged from his service with effect from 4th of April 2024. So in that regard, he has placed before this court a set of instructions which are collectively kept on record and marked with the letter X. Further to that, the order of discharge dated 4/4/2024 have also been placed on record, which is kept on record and marked with the letter Y. Taking into account that the petitioner had been already discharged from service, the very edifice on which the instant writ petition has been filed seems to be misconceived, and without there being a challenge to the order of discharge dated 4/4/2024, no relief can be granted in favor of the petitioner. Accordingly, this court therefore dismisses the instant writ petition on the ground that it is a misconceived writ petition. However, it is observed that if the petitioner is aggrieved by the order dated 4/4/2024, a copy of which was handed over by Mr. Ardhar, the learned counsel appearing on behalf of the state respondents, to Ms. U. Hazarika, the learned counsel for the petitioner, the petitioner would then be at liberty to approach this court by filing a fresh writ petition. What is 58? Same,
Supply item 58 lordship.
same.
And customer order their lordship next week lordship.
We'll see when the matter reaches.
The petitioner had applied for the Anganwadi worker lordship. The last over in 22 September 25, the respondent side lordship took time to go to the survey register of the concerned Anganwadi center.
Yes, who is appearing for the respondent? You are appearing?
My lord, I am appearing, my lord.
Social welfare.
Social welfare, my lord.
What happened? What is your instruction?
My lord, instruction is still awaited, my lord.
Huh?
The instruction is awaited, my lord. We have written letters though on 17/12/25. We haven't received the instructions as of now, my lord. My lord may cause if notice goes, my lord, it will be easier for us even, my lord, to file. an affidavit.
Yes, that is the problem. Without a notice, you cannot get it. Yes, what is your case?
My case is we are the location of the concerned Anganwadi center lordship we applied, but our candidates are all rejected.
Huh? Your application was rejected.
Lordship.
Both of you applied for the same place.
Center lordship. Petition number 1 applied for the Burungkatuli Anganwadi center and petition number 2 applied for the Ligipa under the same CDP lordship.
But are the cause of action not different?
Both of them same.
How?
Lordship, the petitioner number 1 is rejected. There's
Where is the rejection?
out of
My lord will come to page number 41, my lord.
41.
Writ petition.
Yes.
Serial number 62, my lord. This is one of the petitioner
Petition number 2.
Out of the survey area.
out of the survey area, my lord.
And the other is
And page number 42, my lord.
outside the survey area.
76.
No, 43.
Huh?
40.
Nazra and Marufa Begum.
Serial number.
Where is Marufa?
Page number 43.
43.
43.
Out of the
Marufa.
survey area. Now, what is your basis on which you are saying that you are from the survey area?
So I will survey the lordship with the
Huh?
Gapurdan lordship issue certificate. And it's a 10 lordship, page 47.
Borunga Toli, so and so. Let us see the advertisement.
Then lordship page number.
Where is the advertisement?
Page number 20 lordship. Clause number 1.
Issue notice making it returnable on 11th of February 2026. Mr. Ardhor accepts notice on behalf of all the respondents.
My lord.
Extra copies of the writ petition be furnished to him during the course of the day. The petitioner herein are aggrieved. Petitioners herein are aggrieved by the rejection of their candidature for appointment to the post of Anganwadi workers on the ground that they were found to be outside the survey area. The counsel appearing on behalf of the petitioner has drawn the attention of this court to the certificates issued by the Gaon Pradhan, Office of the Gaon Pradhan.
It's for this coming.
Only one. Where's the other one? Huh?
Submitted the
Where's the other one?
only the application is filed.
Refer to the certificate issued by the Gaon Pradhan in respect to the petitioner number
One.
1 and submitted that the said certificate clearly shows that the petitioner number 1 belong to the survey or area of Burungatoli, Anganwadi Center under Lanka ICDS project. Full stop. However, in respect to the petitioner number 2, no such certificates have been placed on record. Under such circumstances, this court therefore does not find any illegality in the putting the petitioner number 2 in the select list, in the rejection list. However, in so far as the petitioner number 1 is concerned, the respondents herein are directed to file the affidavit as to whether the petitioner, as on what basis the said respondents have come to an opinion that the petitioner number 1 do not belong to the survey area. The said affidavit be filed on or before 6th of February 2026. Petitioner number 2, no case. Only one. No, go on. If you are waiting for an affidavit to be filed after such a long time. What is this? Huh? What happened to him? What type of affidavit is this? Huh? Mr. Counsel, what is your name? Huh? Manzoor Ilahi. Okay. No, your name. BC? ABT Hawk. Okay. Now, who has filed this petition? Some Bikas Kumar. Who is he? And he has not signed the Wakalatnama. Hey, second file is how? Oh, he has filed the Wakalatnama. Okay. Now tell me why I asked you. Why the affidavit is blank? See this affidavit? What type of affidavit is this?
I'm sorry, Your Worship, I may be allowed to.
So your affidavit on the basis of which you have filed the writ petition is wrong.
I may be allowed to correct it.
How can you correct it now? So if you correct it, that is not he who is saying it. How is it possible? Tell me, give me a good reason. When an affidavit is blank,
And we will have to withdraw this petition and fresh.
better. Because this affidavit you cannot proceed. It's wrong. What is the impugn notification?
One.
Whereas in compliance with the direction dictating man and man, the governor of Patami speaks to withdraw the government order of discharging so and so from man, so and so. Hence, is very favored on who the case of one who was on probation in some days considered. On people control and. This is to do with those matters, na? Those APSC scam matters. You need to come up properly because later on you will have a problem because this will be a highly contested matter. The learned counsel appearing on behalf of the petitioner, Mr. A.B.T. Hawk, submitted that there are formal defects in the instant writ petition so that he may be permitted. And as such, he may be permitted to withdraw the instant writ petition with the liberty to refile. Full stop. Ms. M. Bhattaji, you appear
Yes, Lordship.
for the respondents and submits that she has no objection to the prayer for withdrawal with the liberty to refile. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Full stop. It is observed that the withdrawal of the instant writ petition shall not preclude the petitioner to refile by removing the formal defects. Be careful next time. None represents the health department when the matter is called. What is this
Lordship,
matter
I
about?
have received the instructions and affidavit has been sent for vetting, Lordship.
The hospital by the. Where is voluntarily retired?
Page 13, my lord. Resolution number 5, my lord.
Yes, madam, what is your instruction?
Lordship, I have sent the affidavit for vetting, Lordship. So the 7 days time may be given to file the affidavit.
Anyways, I think we should issue notice.
Notice already issued, Lordship.
No,
No?
It's not.
that is the reason why the matter has come up.
Lordship.
Okay. Issue notice making it returnable on 13th of February 2026. Miss, your name?
MS Deborah.
Ms. Deborah, the
Standing
Standing
Counsel.
Council of the Health Department accepts notice on behalf of respondent numbers 1, 2, and 3. As regards the respondent number 4, the petitioner is directed to effect service by way of speed post. Now, extra copies be served upon him during the course of the day. as regards the respondent number 4, the petitioner is directed to effect service by way of speed post and steps be taken by tomorrow. In addition to that, the petitioner is given the liberty to effect service upon the respondent number 4 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner was appointed as a grade 4 employee in the Putimari Mini Primary Health Center on the basis of a resolution taken on 8/10/2010. It is the further case of the petitioner that with effect from 1/6/2018, she had been receiving salary / honorarium for her service. The grievance of the petitioner is that on 18/8/2025, the Hospital Management Committee have discharged the petitioner from her services, showing that the petitioner has voluntarily retired with effect from 1/9/2025, though the petitioner never sought for any voluntary retirement. It is the allegation of the petitioner that the same has been done at the behest of the respondent number 4. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 11th of February 2026 as to why the petitioner have been voluntarily discharged from service as voluntarily retired, though the petitioner have not applied for any voluntary retirement.
She was engaged, Lordship. She was an engaged employee, Lordship, on humanitarian ground, Lordship.
Understood, but why are you putting it voluntary retirement? You
Lordship.
are giving him
I'll
the
make
benefit
it
of death only. First of all, your people they don't know the difference. What is this retirement?
Yes.
If you are engaging him just for anything as a casual employee, you have to discharge him.
Yes.
But why you are putting it as voluntary retirement?
Obliged.
Yes, Pinta Deka.
Lordship, the petitioner has come for an appeal for remeasurement, Lordship. He was rejected for the less height of it.
Age?
It's required is 165 centimeter.
Less height. He was rejected on physical standard test, Lordship.
Standard.
On height.
Height.
Ground of height, yes.
What is your age?
Lordship,
Age
the petitioner, age
20. 20. And where is the height consideration?
height rejection, Lordship, he has rejected the slip, Lordship. Misplaced the petitioner has misplaced his slip, Lordship. Rejection slip, Lordship. So he could not annex that rejection slip, but he has annexed the certificate from the doctor.
Where is the height regulation?
Height regulation is at page 30, Lordship. 12.5, Lordship.
Ah. You are from Assam,
I am from Assam, Lordship. Yes, Lordship.
so it is 165.
165, Lordship.
Your National Health Mission says it 165.2.
Yes, Lordship.
Okay.
So
Now, this is one aspect, but the most pertinent aspect, have you looked into that? This is done under the CRPF.
here.
Have you seen the CRPF rules?
Lordship, it is conducted by CRPF, but it is under Staff Selection Commission, Lordship.
Have you seen the CRPF rules? You see, that is why I asked you, what is his age? Age is 20.
20.
So there is a chance of some 1%, 1 or 2 inches height may be given in this as per the CRPF rules. Have you looked into that? Oh, it's for me to help you out. Yes, what are you?
I have received instruction, Lordship, that he has not annexed the admit card and rejection slip. Therefore, it is not, it is difficult to where his PST was conducted. The concern caps
Just 1 minute.
where
Just 1 minute.
Roll number.
Huh?
Provided his roll number from registration number, Lordship.
I have received this instruction, Lordship. That's why it is difficulties to find out.
Roll number.
No, madam, it's not a good instruction.
You don't have the rejection slip.
I don't have the rejection slip, but my statement is there that I have been rejected for 164.4. Now, Lordship, there is a provision for appeal
Ah,
in the advertisement itself.
Meghalto.
Page 32, Lordship. Clause 12.5.5. But that appeal has to be required within the same day, Lord. It's not possible for the petitioner to file that appeal. That's why the petitioner has come before your Lordship. Similarly,
Where?
at page 32, 12.5.5, Lordship, clause. The candidates who
Who are declared not fit in physical standards may
present
prefer an
and
appeal on the same day
present
if they desire
same
to
day.
appeal it or nominate for the
This
sentence
is
to the presiding
appellate
officer.
authority
And
nominated
will
for
be
the
final and no
stand-up.
further appeal or
To the presiding
representation in
officer, the decision of the
the
appellate authority will be final. And no further appeal or representation in this regard will be entertained thereafter. Now, Lordship, under this provision for appeal, similarly situated candidates have already been allowed by the coordinate benches.
Hmm.
This honorable.
But they have annexed the rejection slip and admit card, Lordship.
Huh?
Admit card and rejection slip, he has not annexed. And that's why where his PST was conducted, it is not find out by the authority, Lordship. It is difficult for the authority to find out where his PST was conducted.
Roll number, Lordship.
And this instruction I have received.
Page 20, Lordship. SOB, page 44.
Page?
Page 44, Lordship. Journal Apekin Abdul Mannan, registration numbers, so and so roll numbers, so and so. Computer generated. This is computer generated.
From the roll number, can't you trace it out?
It became difficult is actually first test, written test was conducted. After that, after written cleared of written examination, the PST and PET was conducted, and in different caps, it was
Now
conducted.
tell
by
me,
the
why
different-
don't you have the admit card
So for my knowledge, he has misplaced it, Lordship. That I do not.
as well as the rejection application also? Then I don't think he is fit to be a constable. That case, not fit. Well,
But throughout the recruitment process, they have only one roll number, Lordship. That only appears in the select list itself, Lordship. How can they just say that with the roll number, they cannot find out a candidate where he has given his PST or written? Does not matter, even if the samples are different, the roll number is all same for the whole recruitment process. All I'm asking for an appeal, Lordship. I'm not asking that they just pass me.
You are not asking for an appeal. You are asking for an appeal. There are kind judges who have allowed it. But the fact that you were required to file the appeal on that date, you have not taken that. You do. When was your rejection? That also you don't know. Then how do you know anything? And then you went to the GMC, National Health Mission, and they say that you are 165.2. Best. Have you approached them, informing that you have lost the? Then and when was your rejection?
That date I do.
Was it after or before going to the National Health Mission?
But before that,
Huh?
it was before going to the National Health Mission.
What is this name?
Zainal Abidin.
Kindly come to page 45. What is this? Joinal Abidin 20 years 30629. What is that?
That would be the Lordship hospital's number, OPD number.
And who is this doctor? No idea. Ah. With due respect to my learned coordinate bench, when the stipulation is only one day, on the same day, you have to file an appeal. The learned coordinate bench have, don't you think, have changed the basic condition of the advertisement by giving him 2 weeks time? What do you say? This will open a Pandora's box. Means everybody will come in.
It is also not possible for the same day because sometimes the PSC happens in the evening time, Lordship. And thereafter they just closes it. As per my instruction, as the candidates come and approaches us. Lordship,
So the next day, did he apply for appeal?
They don't take next day, Lordship. They don't take next day, Lordship. They take only on the same.
Did you apply on next day? I'm asking you.
They just go and approach. They are not entertaining, Lordship.
Because this happened when? 2000? It must have happened sometime in 2025, September. September. So when did you file the petition?
It's October.
Huh?
We filed it on 3/11/2025.
Yeah. You have not even approached them. Issue notice making it returnable on 13th of February 2026. Ms. S. Borua accepts notice on behalf of all the respondents. Extra copies of the writ petition be served upon her during the course of the day. The grievance of the petitioner herein is that the petitioner was found to be grievance of the petitioner herein is that in the physical standard test, more particularly in respect to height, it was found that the petitioner's height petitioner did not have the height of 1.165 centimeters, which is the basic necessity in terms with clause 12.5.1.3 bracket D of the notice dated 5/9/2024. The learned counsel appearing on behalf of the petitioner submits that in the meantime, the petitioner have lost his admit card as well as also the rejection slip. The petitioner thereupon measured his height in the National Health Mission, and it was found that the height was 165.2, isn't it? Full stop. The counsel appearing on behalf of the petitioner submitted that this court had passed, the learned coordinate bench of this court had passed certain orders, thereby permitting similarly situated petitioners to prefer appeal within a period of 2 weeks. Full stop. This court also heard Ms. S. Borua, the learned counsel, appearing on behalf of the respondents who submits upon instructions that it is very difficult to obtain the details as regards the petitioner, taking into account that the petitioner have not enclosed the admit card as well as the rejection slip. Full stop. The learned counsel appearing on behalf of the petitioner, rejoining to the submission submitted, that the petitioner pursuant to the notice dated 5/9/2024 had submitted his application and he was given a registration number and a roll number, and the details of which is there in Annexure B to the writ petition. The learned counsel therefore submitted that on the basis of the registration number and the roll number, which remains the same till the culmination of the recruitment process, the respondents can very well find out the admit card as well as the rejection slip. This court prima facie is of the opinion that based upon the registration and number and the roll number, the respondents can trace out as to whether any admit card has been issued in favor of the petitioner, and as to further as to whether there was any physical standard tests conducted upon the petitioner, more particularly in respect to the height. Accordingly, This court therefore directs the respondents in the interim to trace out the admit card as well as the rejection as to whether there was any rejection of the petitioner in the physical standard test and place the same before this court on the next date without fail. Absolutely no, you don't have anything. What is this?
Malada, this is. I make it, petitioner is the applicant of Malada, equipment process of SSC Malada, State Election Commission. Initially, he was completed, his step successfully. But after Malada, detailed medical examination, by a detailed medical examination board, he was referred for review medical examination. And by review of medical examination board, rejected the applicant. Malad, that is impugned rejection is page 69. Malad. Paragraph 3A and B. Malad. Detailed medical board was rejected him on the two grounds. One is Malad, varicose veins, another is Malad, vitiligo.
Where? Page
69.
Ah, 69. Final opinion, fit for varicose vein, unfit on account of as it can an autoimmune disorder with unpredictable prognosis. Okay, then
Hello.
what happened?
Kindly peruse General Rule of Review Medical Examination Board, page 73.
73.
Malad. Malad, the relevant bottom is page 76. Malad. Clause 6D, guidelines for review medical board. 76 Malad. Clause D Malad. Top side. Review medical board may obtain opinion of concerned specialized or super specialized of government medical college and hospital in case of any doubt. Therefore, in case of rejection in review medical examination, clinical findings should be corroborated with confirmatory test, oblique investigations, oblique opinions of specialized, super specialized of government hospitals, medical college, oblique government approved private medical centers, whichever and wherever applicable. But then kindly peruse, my lord. I was also examined by the specialized, that is, my lord, Bangor Medical College, GMCH, my lord. That opinion is page 60 for which.
This is prior to this.
Malad.
This opinion is prior to that.
No, my lord.
Obviously.
Yes, prior to that.
Then why did you had the occasion of going out there and having an opinion earlier?
No, my lord, this was conducted by the
So
RME.
you knew it beforehand.
RME conducted. This specialized examination was conducted by the RME. My lord.
Who?
Review medical examination board.
By?
My lord.
Done by?
Review medical examination board.
Who does it? No.
RME, my lord, this is according to the general guidelines for review medical examination board, my lord, clause 6D. They are examined by the specialized, my lord. In that opinion, my lord, I was examined by the one specialist of dermatologist, my lord. Page 64, my lord, that opinion.
By? Dermatologist
Dermatologist.
and STD.
Department of Dermatology and Guwahati Medical College. The patient has depigmented macular lesion around the anal region vitiligo, which is a non-contagious, my lord, and treatable condition. The patient does not have any other signs of any acute or chronic illness at present and is otherwise fit to perform his duties. It is the specialized opinion, my lord. And non-contagious meaning, my lord, it is not spreadable by contact, my lord. And the department, my lord, rejected me on the ground of, my lord, that is Page 88, my lord. General grounds for rejection, my lord. Rules. 619.
But Mr. Counsel, tell me, why on earth did you go to the Guwahati Medical College one day before?
Process, my lord, they are conducted, my lord. Not
They?
by me, yes. Not him.
So this is done by them?
Yes, done by them.
Okay. So in spite of this opinion, the review medical board has come up with this thing.
Yes, my lord. But they
That
are
is
not
why you are
considered-
saying.
According to my submission, my lord.
But it doesn't refer to any opinion of the Guwahati Medical College.
Yes, my lord, that was not my, lord, I taken into consideration by passing this opinion.
Here, may I please, Lordship, general ground is vitiligo. If vitiligo is the general ground, Lordship, mentioned in the, as per the guideline of recruitment process 2015, as per guideline.
Where?
Uh,
Page 88, my lord, that I have annexed with my picture also, my lord.
Which one? Number?
619, my lord.
19,
Chronic
general ground
skin
of
disease
rejection.
like vitiligo.
General ground of rejection, Lordship. Vitiligo is detected by the GMCH authority, Lordship. It is vitiligo. And respondent on the that ground, vitiligo rejected the petitioner.
But
It
you
is a
see
treatable-
here in the opinion which was given at page 65, the patient does not have any other signs of any acute or chronic illness at present.
That are not there, but vitiligo is there. As per the guideline, vitiligo on the, if chronic skin disease like vitiligo, leprosy, vitiligo is there. And the treatment is not the duty of respondents, Lordship. It is treatable. Here it is that which is a non-contagious disease and a treatable condition. It means a treatment is required. And treatment is not the
But what do
responsibility
you mean
of the
by the word chronic?
Chronic means, my lord, the disease which contains for long time. But which is not, my lord, affect with the, my lord, performance to perform his duties, my lord, according to the expert of me.
and other signs of any other any acute or chronic illness. It is not there. A vitiligo is present, and the vitiligo is a
But your vitiligo is prior to that there is also some adjective. Chronic skin disease.
chronic skin disease like vitiligo.
So it has to be chronic. What to
Any
do?
other signs of patient does not have any other signs of any acute or chronic illness at present. But
Now, we
treatable
can't
condition-
say him to be fit by this court. But what can be done is what? What order can be passed by this court?
I have otherwise received paravase complaint, may file, I can file.
You have got a paradise comments.
Here it is,
Have a look at it.
with your lordship permission, I would like to submit the glance, my lord. In my case, my lord, I am saying for the vitiligo, my vitiligo is chronic or not, that point has to be ascertained. On the other hand, my lord, expert examination conducted by them, my lord, but in the impugn rejection, no whisper about say expert examination. My lord.
Here they have given,
My lord.
they have taken on the basis of that.
In similar situated cases, my lord, subject to your lordship permission, I would like to submit one Delhi High Court judgment, my lord. Division bench judgment, that is probably in record, my lord, on one earlier that I was submitted there. Delhi High Court judgment.
No. What does it say?
My lord, the 11th para, I would like to read out, my lord.
No.
Paragraph 11, in the present case as well, though the petitioner does not dispute that he is suffering from genital vitiligo, he submit that same would not in any manner affect the discharge of his duties and that his condition is stable. These issues, including whether genital vitiligo can be said to be chronic skin disease, are to be determined by medical expert. Paragraph 12, following the judgment of this court in Durga Singh Chopra, Durga Singh also I have placed below. We therefore direct the respondents to constitute a fresh medical board to re-examine the petitioner within a period of 3 weeks from today. The medical boards must include the dermatologist. The medical board, however, should not be constituted of the doctors who were already part of the impinged DME or RRB. So I have listed my case kindly refer to this aspect to re-examine me whether my vitiligo is chronic or not. That direction may be given in this case. So I'm thinking of it.
Come here.
Second one paragraph.
Think we allow his petition to that effect and you examine as to whether it is chronic or not. If it is chronic, he goes. Because keeping this matter pending would not serve any purpose out here. That is my only thing. And I've seen your instructions that you also did not go into the question of chronic.
Yes.
The instructions are that it is autoimmune and all these things, but this is not backed by any medical documents to that effect. But the only thing is whether it is chronic or not. If it is chronic, fine. That seems to be the fair thing. Because keeping these type of matters pending is going to harm you at a later on as regards the recruitment process.
Yes.
Shall heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. S. Borua appears on behalf of the respondents, all the respondents. The present petition has been filed by the petitioner challenging the impugned opinion of the Review Medical Examination Board dated 24/11/2025, whereby the petitioner has candidature was rejected on the ground that on account of vitiligo was rejected. Petitioner's candidature was rejected as on the ground that it rejected as unfit on account of vitiligo, as it is an autoimmune disorder with unpredictable prognosis, spelling to prognosis, prognosis. Full stop. The brief facts which lead to the filing of the instant writ petition are that on 5/9/2024, a notice was issued for recruitment to the post of Constable GD in the Central Armed Police Forces, (CAPF-S) and SS, Rifleman, (GD) in the Assam Rifles and Sepoy in Narcotics Control Bureau Examination 2025. The petitioner participated in the said recruitment process. Full stop. At the time of medical examination carried out, it was opined that the petitioner was unfit. At the time of detailed medical examination carried out, it was carried out on 18/11/2025. The petitioner was declared to be unfit on account of two diseases, that is, number one, varicose veins, and number two, vitiligo around anal canal. The petitioner thereupon sought for review. Under such circumstances, the petitioner was referred to the Guwahati Medical College and Hospital, wherein the dermatologist in question gave an opinion on 22/11/2025. The opinion reads as under, inverted comma, the patient has depigmented muscular lesion around anal region, bracket, bracket, here is a small triangle at the page 65 of to quote so and so. From the above quoted opinion, it appears that what was opined was that the petitioner has vitiligo and was non-contagious disease and was in a treatable condition. It was also opined that the petitioner does not have any other signs of any acute or chronic illness at present. And the petitioner was further fit to perform his duties. Subsequent thereto, the Review Medical Board examination was conducted, wherein it was held that the petitioner was otherwise fit for varicose veins, but was declared unfit on account of vitiligo, as it is an autoimmune disorder with unpredictable prognosis. It is under such circumstances the petitioner has approached this court by filing the present petition. The materials on record reveal that when the matter was initially listed before this court on 8/12/2025, on 10/12/2025, instructions were sought for. In terms with that, Ms. S. Borua, appearing on behalf of the respondents, have placed a set of instructions dated 9/1/2026, wherein it was mentioned at paragraph number 4 that the petitioner was afforded an opportunity to apply for the review medical examination, and the petitioner availed the said opportunity and reported on 20/11/2025. The Review Medical Board, after examination, referred the petitioner to the GMCH Hospital, Guwahati, for consultation with the skin department. And the SIN's consultant, after the required examination, diagnosed, inverted comma, vitiligo and prescribed medicine. It was further mentioned that there was a confirmation of the diagnosis of the detailed medical examination board. Further to that, it was also mentioned that the vitiligo is an autoimmune disorder and is sometimes associated with autoimmune and inflammatory disease such as Hashimoto thyroiditis, It was also mentioned that there is no cure for vitiligo, but several treatment options are available. Bag of fiber, the Learned Counsel, this court have heard the Learned Counsels appear, the said instructions are collectively kept on record and marked with the letter X. This court have heard the Learned Counsels appearing on behalf of the parties. Attention was drawn to the guidelines of the recruitment medical examination in Central Armed Forces and Assam Rifles, dated May 2015, wherein at clause 6, bracket 19, chronic disease like skin disease like vitiligo, leprosy, SLE, enzyma, chronic extensive fungal dermatitis have been mentioned to be general grounds for rejection. The Learned Counsel appearing on behalf of the petitioner has further drawn the attention of this court to an order passed by the Learned Division Bench of the Delhi High Court, in the case of Rahul Kumar versus Union of India and others, dated 16/10/2025, whereby there were certain directions being issued to have a fresh review medical board to assess as to whether the vitiligo was chronic in nature or not. This could have given an anxious consideration to the respective submissions and have also perused the materials on record. This court does not have the expertise as to whether the vitiligo, which is presently, for which the petitioner presently suffer from, is chronic in nature or not. Taking into account the judgment of the Supreme Court in the of the Delhi High Court in the case of Rahul Kumar Supra, it is the opinion of this court that the responding authorities, more particularly the respondent number 5, should be directed to reassess as to whether the petitioner herein is suffering from any chronic, whether the disease which the petitioner suffers is chronic in nature or not. This court also finds it pertinent at this stage to take note of Clause 6D of the Guidelines for Review, Medical Examination (RME) in the Central Armed Police Forces and Assam Rifles, which, being relevant, is reproduced here in under page 76 of this. It is the opinion of this court that as to whether the petitioner presently suffers from any chronic disease, has to be decided on the touchstone of Clause 6D of the guidelines. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The respondent number 6 is directed to reassess, to re-examine the petitioner within a period of 3 weeks from the date the petitioner submits a certified copy of this order. To assess as to whether the disease presently suffered by the petitioner is chronic in nature or not. Such decisions shall be taken by taking into account Clause 6D of the guidelines. Number 2, the petitioner shall submit the certified copy of the present order to the respondent number 6, to the respondent number 5, within 10 days from the date of the present order.
Subsequent examination board could not contain the earlier document. But if subsequent examination board not contain with the earlier doctor who are examined it.
Mr. Counsel, you are lucky enough to get this order. Delhi High Court giving it out there doesn't mean that I am going to give you that. Where's your Malaf ID? Tell me, where's your malafide that this particular dermatologist should not be there? This particular review medical board person should not be there. Where's your allegation of malafide against them or bias against them?
No, no allegation.
So therefore, should I say that these doctors should not be there? When I am only asking them to reassess as to whether it is chronic or not.
My lord.
If I say that this particular doctor should not be there, therefore am I not giving a finding out here upon that particular person concerned that he is not, he doesn't have the expertise. So therefore, you have to amend your writ petition.
That is good. That is good. That is
So
not-
why don't you file a fresh one?
That can be done.
That's the only way out.
That could be done.
Name of the respondents are also not properly mentioned, lordship. 1 and 2. These should be women and child development, lordship. These things are not. Like number 1.
Mr. Day, I put his name only. Mr. B. Pathak, the learned petitioner in person, submits that in the meantime, the select list have been issued, published.
One.
It's okay, in the meantime. And in order that the petitioner can be granted in relief, the petitioner needs to challenge the said select list. He therefore submits that the petitioner would like to withdraw, he would like to withdraw with the liberty to refile by challenging the select list. Taking into account the above, the writ petition therefore stands closed on withdrawal and thereby granting liberty to the petitioner in person to refile by challenging the select list. This court also comments on the assistance provided by Mr. R.D., the learned counsel, at the request of this court, vide the order dated 7/1/2026.
Item 8.
Ms. So-and-so appears for suit.
Selection and appointment method for Anganwadi helper, Anganwadi worker method,
Huh?
Anganwadi worker.
Then what happened?
But the petitioner belongs to Kashtabari or Garumari Anganwadi worker. And respondent number 5, staying outside of the survey village, she was staying at Kaur Hagi. Originally, respondent of 5, born and brought up at Goromara Doloni and married at Kaurhagi, which is outside of the survey village. Let selection list member
Has the appointment been made?
made to the respondent number 5, page in annexure 3, page 37 to 38, relevant portion is 38, serial number 26.
Where?
And there are to file the representation for cancellation
Huh?
of the respondent.
Serial number?
Page number, my lord. Relevant portion is page 38, my lord.
Serial number?
Serial number 26.
She has been selected.
My elected and selected.
Appointment order?
Appointment order is not included, madam. That was not unable to correct, madam.
Huh?
Unable to correct.
You say that she belongs to where?
Madam, one Kaur Hagi, madam.
How do you say so?
She is outside of the survey place.
Huh?
Survey, outside of survey place. The Anganwadi center is belongs to Kotsaburi, Boromari, Anganwadi center.
Where?
Madam, that was about, madam, 10 to 15 kilometers distance from Kotsaburi to Kaurhadi.
Mumtaz Begum.
Mom-
Father's name?
Father's name, my lord, he made now, her husband name is Nasiruddin, my lord.
No, where do you say that she does not belong to the survey area?
One town, Gura certificate is there, annexure 5 shows 41 to 42, my lord. Annexure 5. And there are two voter lists, my lord. Annexure 2 and 2A.
She is area of Kawar Hagi.
My lord.
And a Gaombura from village number 1, Burgao, certifies that the respondent number 5 is from village Kauhargi.
Our Hagi.
How is it possible?
Fine.
A Gaombura from another village certifying that this person resides in some other village. How is it possible?
My lord, this two voter list will prove that she is native village is at Goroma Colony, connection 2A. And another
Page,
voter list is
page.
my lord. Page, my lord, 29 to 36. my lord.
Huh?
29 to 36.
29 to 30.
Right.
What does it say?
Page 31, serial number 533. And 2A, serial number 677. Page 34.
Hello, we issue notice. Issue notice making it returnable on 23rd of February 2026. Ms. Mbachese accepts notice on behalf of the respondent numbers 1, 2, 3, and 4. As regards extra copies during the course of the day. As regards the respondent number 5, steps be taken by way of speed post by tomorrow. In addition to that, the petitioner is also given the liberty to effect service upon the respondent number 5 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the enlisting of the respondent number 5 in the select list for the Karsua Bori, Bora Mari, Angandwadi Center on the ground that the respondent number 5 do not is not a resident of the surveyed area. In that regard, the petitioner have placed before this court the certificate issued by the Gao Pradhan as well as the voters list to substantiate the claim of the petitioner that the respondent number 5 does not belong to the surveyed area. It is further seen that the petitioner had submitted representation on 3/9/2025. However, the said representation having not been considered, the petitioner has approached this court. Most of the respondents herein are directed to bring on record the stand by filing the affidavits on or before 18th of February 2026. Full stop. It is observed that any appointments so made to the respondent number 5 shall be subject to the outcome of the writ petition.
Deeply obliged.
But this is matter relating to the calculation of family pension. Yes, kindly see page 23.
Yes.
Clause number 3. Consider division of pension, family pension. Pension, so and so, existing pensioner, family pensioner, E11/2006 pensioner shall be consolidated revised with effect from 1/1/2006 notionally by adding together. Next, B kindly see. The above computation is subject to the following condition. The revised basic pension in no case shall be lower than the 50% of the sum of minimum of the pay in the pay band and grade pay thereon corresponding to the pre-revised pay scale from which pensioner had retired. While they have calculated, they have taken into consideration 3A without considering 3B. And with respect to this, my lord, this honorable court earlier in different case, my lord, this point has been dealt and decided that while family pension is to be calculated, 3B is also is to be considered along with 3A. And if 3A is more than the 3B, then 3A will be applicable. And if 3B is more, then 3B will get not less than 50% of the basic. If with respect to this, my lord, this honorable court has already been decided the point. And now the AG, my lord, in his letter, kindly see page 43. And government also decided this point. Page 43. This two judgment.
No, why are you referring to the 1/6/2010 and not to the 17 one?
Same clause. Same clause. Can we see that annexer 3, madam? Annexer 3. Page 26. 3. What you got it?
When did you retire?
My lord, the petitioner is the family pensioner.
When did the person retire?
This prior to 1/1/2000.
1/1/2016.
6.
Huh?
Prior to 1/1/2006.
6.
And this 26 is after 7 pay conviction. Now, this question was also raised before the government, my lord. Kindly see page 29.
Then after this, page 43.
Page, after page 43, my lord, I have submitted a representation that this matter attains finality and it has already been decided. And the government has also given the clarification with respect to that.
Where is it?
Government clarification page 30. 30. And the judgment, page 30. In the last, from the last paragraph, in view of the above, you are requested to take account of ready reckoner of provision of section 3B1 of municipal sections.
And when did you start receiving the pension?
My lord, petitioner. Petitioner is family pension.
The person concerned.
Concern. She is receiving pension, my lord, 2004. From 2004. At page 1, my lord, I have given the document.
Now here, which is the communication?
My lord,
Which is the communication you are challenging here?
yeah. Yeah, my lord, this communication, my lord, this communication of page 43, my lord.
Page 43 does not say anything.
They are repeatedly, therefore you are requested to edify the office whether the clause 3B1 or 7 is applicable to all family pensioner.
No, did you ask for that family pension as per the
Yes,
clause 3.1? Where is that?
my lord, my representation, last representation I have given on page 51,
Huh?
page 51. Initially, I have given to bank also, bank authority. Then bank authority referred to the AG, my lord. Now AG is taking a plea that this clause is, whether this clause is applicable or not.
No, where is that letter which has been written to the PNB?
PNB. My lord,
16/5/2025. Where is that communication?
65, page 36.
Huh? No.
Bank communication, page 35.
Yes, what do you say?
My lord, here we sought some information regarding clarification of the concerned department 12 June 2025 itself. Uh, that so far this whether I have received or not, because that is June 2025. Now notice my issue in detail will reply to that effect, my lord. Here two questions are put. First question is regarding TB1, another question was put regarding one judgment. Whether it is appeal filed or not, it is to be clarified this department. That is a distraction we are waiting. If we have received, because I have to take instruction.
You
from
are
that.
waiting for this instruction from
12 June 2025.
6 months.
That order has already been implemented.
6 months.
Now let me take instruction, my lord, to that effect. Because notice may go, otherwise you will file with detail affidavit. Because it is a if this is or he is entitled, definitely will get it, because I have to give clarification ethics. Notice may go, my lord, today.
Dr. Vidya Goswami's case, my lord, where same issue has been raised by the AG earlier also.
No, that
And
entire
that has
things
been
will be dealt
decided.
with by in
Same
petition, my
issue
lord.
And same has been raised earlier also by the AG.
Entire matter will be dealt in my affidavit of position, my lord.
Why are you making this chief manager Punjab National Bank a party?
Because they are drawing and disbursing authority.
Understood. Why are you making him by name?
by
That
name
is the
because
my question,
they-
my lord.
Because in,
Where is the allegation of bias
I
or
have
malafide?
that they are not complying they are not
That is
They
in
are not
official-
doing it.
that is
the
in
official
official
is not
capacity, my
doing
lord.
it. Why are you making it by
Yes.
name? Are you not delaying the process?
his name may be stuck up. I have no.
You are making 3. Then again, why are you making the senior accounts officer by name?
Because senior office.
What is the allegation of bias, malafide? Show me. Where is the allegation of
Senior-
malafide?
Kindly see the letter of the senior officer, my lord.
Where is your allegation of malafide? Don't come up with this type of matters like this. We don't expect Mr. Ghosh, a person of your caliber, to come up with a repetition like this. And why are you making the Punjab National Bank a party? At number 1.
PNB is the necessary party.
Who pays the pension?
PNB, bank is, authority is the bank. PNB.
Bank releases is the disbursing authority. Isn't it?
Finally, see, my lord, annexer,
Yes, I-
annexer 23, page 23, sorry, page 23.
Mr. Ghosh, I may be sitting normally in bench 1 or bench 3, 4, 5, but I know basic thing as to how the pension is disbursed.
My lord, kindly see, page 24, my lord.
So what?
Division of pension, family pension with effect from 1/1/2006 to so and so to be done nationally and on area shall be accrued during this period. Area with effect from same may be calculated and paid by the pension disbursing authority, including selected nationalized public sector bank in a single installment. So power has been given when the past pensioner, if today is the pension is calculation, then matter bank is not the authority. But with respect to past pensioner, my lord, bank is the authority, and this authority has been given to the bank with respect to past pensioner. Because for that revision, they cannot go to the government. My lord. The
Now,
calculation is
at
to be made.
whose behest bank is not paying?
My lord, bank.
At
bank-
whose behest the bank is not paying?
Bank is authorized to do this calculation, my lord. Bank is authorized.
Where is that?
Page 24, my lord.
Yes, show me. Where?
Point number 5. Area with effect on some may be calculated and paid the pension disbursing authorities, including selected nationalized public sector bank in a single installment. So here in this case, after past pensioner, bank is the after bank disbursing authority is the AG, and pension bank is the calculation.
Where is the communication to the bank?
Bank-
Representation?
Page 47.
Huh?
Page 47. Email.
So the reply to that is you find it as this place, page 35. So you are showing that there are two High Court judgments. And they said kindly confirm with the Treasury officer as well as the PPO. Done?
Thereafter, my lord, after I have submitted representation on 23/6.
Issue notice making it returnable on 27th of February 2026. This court is not inclined, on the present facts, is not inclined to issue notice upon the respond number 3 and 5, as there is no appropriate allegation, there are no allegations of malafide as regards the respond number 3 and 5. Be that as it may, the petitioner is directed to effect service. PNB, anybody is appearing? Mr. So-and-so accepts notice on behalf of the respond number 1 and 2. Mr. C.K. Borwa,
four,
C.
four.
Borwa accepts notice on behalf of the respond number 4.
4 only.
And who is the pension department? Mr. So-and, Ms. So-and-so appears for respond number 6. As the respondents, numbers 1, 2, 4, and 6 are duly represented by the respective lawyers, extra copies of the writ petition be furnished to them during the course of the day. So, the case of the petitioner herein is that the petitioner is the family pensioner who have been receiving pension prior to 1/1/2006. In terms with the office memorandum dated 1/6/2010, the petitioner is entitled for computation of its family pension in terms with clause 3B (1). However, The respondent authorities, more particularly the respondent number 4, have denied such entitlement. The learned counsel appearing on behalf of the petitioner submits that the issue is no longer res intriga, taking into account that this court had passed orders in the case of Bijoya Goswami and others versus State Bank of India and others, reported in 2018 5 GLT 122, as well as in the case of Srimati Bulu Borua versus the state of Assam, reported in 2017 2 GLT 856. The learned counsel appearing on behalf of the petitioner further submitted that even the state of Assam had issued a clarification on
7 August 2012.
7th of August 2012. But for reasons best known, the respondent number 4 is not acting thereupon. It is under such circumstances the petitioner has therefore approached this court. Full stop. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 23rd of February 2026. Full stop. It is observed that pending disposal of the pending the next date, it shall not be a bar on the part of the respondent number 4 to take necessary steps, if so advised, in terms with the judgments of the this court in the case of Srimati Bulu Borua Supra and Srimati Bijoya Goswami Supra.
Earlier opinion, ask the settlement council to obtain special matter. Here what happened, matter, the petitioner belongs to Nonia community matter, which is obviously it was central list of 1993. And the certificate that he issued was on 9/7/2008. At the annexer, he matter is 69. Then they applied for, there was a matter, recruitment notice, they applied for the CPO, central people's organizations. They were elected for in the CSA. Then suddenly the said no, the effect certificate. Then we filed an application for verification and re-verification to the district commissioner. The district commissioner verified and again re-verified. What was right next, sir? JNK is 1779. That was his letter, 9/10/2025 and 8/11/2025. And it was found to be genuine. This is the case, matter.
So you filed an appeal,
Yes, then there was a real, case 76,
huh?
case 76,
Then you filed a second appeal.
yes, sir.
What happened to the second appeal?
They said there is no provision for second appeal. There is no provision for second appeal.
Why this is mentioned as second appeal by you? Page 93.
But three mother, we have given the. Because the mother, said, oh, I'm questioning it.
So they say that your certificate is false.
Paul.
Then
Yes, sir.
it's fake.
Yeah. He has said it is bad, right? But you'll have to kindly come to. Is 72. Also. Even Nonia community is not. Not OBC. Then who else?
No, Nunia community may be an OBC, it's a different aspect to the matter. But the question is your certificate has been alleged to be fraud,
Also,
fake.
you'll have to kindly come.
How
to
can we look into it?
Page 72.
Huh?
Page 72.
What is this? Yes.
Rama says with my name. And belong to OBC Dunya community.
When were you appointed?
I was appointed my lord on 19/12/2023.
Did you have a criminal layer certificate then?
Yes.
Where is that?
Familiar, I have an action.
This is the most important thing. If it is a creamy layer, you may be non-creamy layer. Non-creamy layer, you may have it in 2025. At that point of time, if you are affluent, you don't get the benefit of age. So we dismiss. Okay.
I may give the answer producers giving them. That was not in our knowledge or not.
Because your basic case is on that.
No, definitely we are not taking.
So you cannot give a certificate later on. The question is, at that point of time, did you give the certificate?
Yes, I give.
Which is that certificate you gave?
But the.
Huh?
See. 8/12. 9/7/2008. Page 69.
Where? Page?
B minor. Page 69.
This is not a non-creamy layer certificate.
OBC certificate.
OBC certificate won't help you. It would have helped you if that judgment was not there. What is that judgment? 9 judges?
Yes. Then why not?
What is that, Mr. Bora? 9 judges? Indraswani.
That's one.
If Indraswani was not there, OBC, this certificate would have been enough. Where's the creamy layer? At the time of your appointment. Yeah. Mr. R.P. Sharma, the learned counsel appearing on behalf of the petitioner. Senior counsel appearing on behalf of the petitioner seeks for an accommodation to file an additional affidavit, bringing on record the OBC certificate issued in favor of the petitioner at the relevant point of time, declaring that the petitioner is does not belong to the creamier. How much time?
15 years. 10 years.
List this matter again on, give you an unlucky number, 13th of February.
That is lucky.
Yeah, good.
With college number.
I'm appearing for respondent number 1 to 5, Lordship.
11.
What is this?
Divorce dependent daughter. And the petitioner is paying for family pension under both a regular area under Assam Services Pension Amendment Rules 2018. Whether Rule 143 has been amended so as to provide.
Yes, why no family pension issued?
Your Lordship, the case is otherwise covered by a very recent coordinate bench judgment in which I only appeared, and also one coordinate bench judgment of 2019 delivered by Honorable Justice Ujjwal Bhuiyan when he was here. Dependency factor too. সেইটো certificate দিব লাগিব।
Hasib Babu.
উজ্জ্বল Bhuiyan judgment টো পিছত আহিছে। আগৰ তাৰপিছত হাচিবা বেগম হৈছে। হাচিবা বেগমে উজ্জ্বল ভূঞাটো 17 আৰ্জনটো কৰি আছে। 119 আছিল নেকি?
Yes, now what is your case?
My petitioner is a divorced dependent daughter. And we are paying for the family pension under.
Indian divorced daughter of late Philip Soikia, retired upper division under annual drawing pension. Who retired on annual drawing on. Yes, no, married on Iman, but other subsequent to dissolve by judgment. But it was the petition. So we dispose it off.
My lord, only one condition he is prevailing. Here, this judgment, I'm not denying on that judgment, latest judgment is coming. Hasiba Begum, that is 2019 case, year of 2019. There is only one thing is required, your lord. There is no dispute that divorcee will be entitled, but subject to production of dependency certificate with affidavit.
You have a divorce decree, na?
Yes.
Where is that?
Page number 16.
Huh?
16. Chapter 3.
ইয়াতে পিলটো নালাগে, ইয়াতে পিটিশনে আছে তো এইটো।
So divorce granted on 15/9/2014. Isn't it?
The date of order 24/6/2015.
Hmm? Where's your next of kin certificate? Huh? Madam? Where's your next of kin certificate?
It should not have. We can produce it. Lordship.
No, we dispose it of. What do you want?
No, that can be disposed of only, lordship. Next of kin certificate, definitely seal it. But only question is coming
You
here.
can produce the next
Dep-
of kin
There
certificate.
is,
Petitioner has no further mother, she only left with one sister, and she is also married. And she has expressly stated that she has no objection if the petitioner.
So you
has-
produce that certificate that she has no objection, an NOC from that.
Can, produce.
no, if we will be having service, we'll be saying this one, if next of kin, her name is there, we don't have an objection to it. Because until unless her name is not there, we cannot go ahead. Definitely it will be definitely I feel, but only dependency certificate is must, my lord. This judgment also clearly says, lordship, I place also coordinate bench judgment.
Hmm.
Here only question is coming only here, dependency certificate, because one of the case recently it has been there, she was a Anganwadi worker, that is why that was, this honorable court has rejected, because she was
No,
depending.
that is there, number 3. In
That is
view of
there.
this court is of the order who is a divorced daughter and was dependent on the so is entitled to the family members subject to the authorities being satisfied on the dependency factor.
Yes, yes. Now,
So this is-
that, with that observation, lordship may dispose of this matter with the, she will produce dependent certificate as per required provision of law.
She grant 3 weeks of 4 weeks.
Huh?
Dispose of.
Why? I'm passing the judgment in your favor now. But Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. D.P. Bora appears on behalf, D. Bora, na? Appears on behalf
I'm
of
for
the
four,
respondent
madam.
numbers 1, 2, and 3. And Mr. C. Bora appears on behalf of the respondent number 4.
My lord.
The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in disbursing the family pension to the petitioner who claims to be a divorced dependent daughter of late of one Trideep Soikia, bracket since deceased. The brief facts of the case, as would be apparent from the materials on record, is that the petitioner's father, late Trideep Soikia, retired from the establishment of the respondent number 3 on 28/2/2002 upon attaining the age of superannuation. After retirement, late Trideep Soikia was paid pension by PPO number TEZ oblique 73109. Pustak. The petitioner got married with one Pranjal Datta. Na? What is his name? Pranjal Datta. On 18/1/2009. But the said marriage was dissolved by the judgment and decree dated 15/9/2014 passed by the learned Principal Judge Family Court number 1 Kamrup Guwahati in FC bracket civil number 136 of 2010, whereby a decree of divorce was granted in favor of the husband of the petitioner, An appeal thereagainst was preferred, being a met appeal number 12/2015 by the petitioner. However, the said appeal was dismissed by the judgment and order dated 24/6/2015, thereby confirming the judgment dated 15/9/2014, passed by the learned Principal Judge Family Court Number 1, Kamrup, Guwahati, in FC Civil Number 136/2010. The grievance of the petitioner herein, the petitioner it is the further case of the petitioner that upon the dissolution of the marriage, the petitioner started residing with her parents, with her father, with her parents. Full stop. Full stop. Her mother expired on when? When did your mother expire? Huh? Full stop. The mother of the petitioner predeceased her father, full stop, late Tridip Saikia, expired on where's the death certificate? Expired on 4/4/2022. So thereupon, the petitioner, being the dependent divorced daughter of late Tridip Saikia, had applied for family pension, which, however, the respondent authorities have not considered the request of the petitioner. And it is under such circumstances the petitioner has approached this court. First, Ms. So-and-so, appearing on behalf of the petitioner, submitted that along with the petitioner, there is another sibling, that is her sister, who is presently married. And under such circumstances, the petitioner, being the divorced dependent daughter of late Tridip Saikia, is the sole and has the sole entitlement to the family pension. Full stop. This court have duly taken note of that the petitioner had also submitted representation, which, however, have not been considered till date. Full stop. So this court also, the law, this court also heard the learned counsels appearing on behalf of the respondents, who fairly submitted that a divorced dependent daughter would be entitled to the family pension, subject to submission of the dependency certificate, na?
Yes, but any certificate
Who issues?
that he has to
He will give an undertaking that she is not dependent on there's a format.
So subject to submission or declaration. that she
Declaration.
is there.
And another
Subject to-
aspect also is to be detained, Miller. She as she's
Subject
next
to-
of kin in the
A declaration being submitted by the petitioner that she was the dependent divorced daughter of late Tridip Saikia during his lifetime.
Same is to be verified by the concerned department before sending to us.
The learned counsel for the respondents further submitted that that the coordinate benches of this court have passed certain directions in respect to similar issues. And refer to the judgment in the case of so-and-so versus so-and-so, that is in WPC number 8395/2019, whereby the learned coordinate bench had passed the following directions in the order dated 30/11/2021. এইটো কেছত paragraph 8 যোনকেইটা আছে, paragraph 8 খন তুলি দিব,
এইটো আছে নাই?
1, 2 and 3.
আছে নহয়?
It is the opinion of this court that the petitioner herein, being similarly situated, would also be entitled to a similar relief, subject to the necessary verifications.
Verification regarding next of kin, etc.
Accordingly, this court therefore disposes of the instant writ petition.
এইটো তুমি দিয়া নাছিলা নেকি?
Thereby directing the respondent authorities to consider the case of the petitioner for grant of family pension
ভোট দিয়ালে
in view of the expiry of her father, late Pradeep Saikia, who expired on 4/4/2022,
নম্বৰটো কিমান আছিলে এইটো?
by making necessary verification into the dependency factor. The said exercise be completed within a period of 3 months, 4 months, 3 months.
After receiving.
3 months from the date, a certified copy of this order, along with the dependency, the declaration as regards the dependency, is submitted by the petitioner to the respondent number 4.
That is, yes, by
Oh.
the concerned department. That's not for me. They have to send it.
To the respondent number 3,
They'll depend to department.
To the respondent
Department
number
in
three.
turn will send to me.
3 months.
Well, oblige.
Item number 11. That's for standard. The petition number 2 protested lines.
Yes, madam.
This is with regard to the benefit. This petition is with regard to the benefit of ROP's rules. My lordship might remember that day one better.
Why do you come up with all difficult type of cases? Huh? This ROP and all. ROP, we are going to have a 8th ROP and you are coming up with a provision of ROP 1990 in the year 2025, 26.
You might remember that day one matter came up. It is that matter. This is the second round of litigation, my lordship. My lordship. My lordship, by page 68, my lordship.
Here, similar order will be which one?
My lordship, page.
Paragraph 5 and 6,
Uh,
isn't it? Which is to be quoted.
Yes.
Here it was 11 and 12.
my lordship.
We'll have to quote to 5 and 6, isn't it? এইটো লগত মিলাই দিব হা ইয়াত খালি paragraph 5 and 6 to quote কৰি দিব isn't it?
Yes, my
5 and
lordship.
6.
Yes, my lordship. Yes.
Reena Moni Kolita, Nirupama Chaudhary, 2 persons. How many petitioners here?
And Ganga Bharali,
Huh?
3 persons, page 3, my lordship.
Where is Ganga Bharali? Oh, yes, yes. There. A order to নিশ্চয় হ'ব, huh? Paragraph 3 and 4, 5 and 6. হয়নে? 5 and 6. আৰু ইয়াত হ'ল refer to consult for the response number 1, 2 and 3. 1, 2 and 3. Okay, shall apprise the spot and take necessary as regards the learning coordinate bench order dated so and so in so and so. Huh? Yet order to date to yet yes. 17.5. You are paying for 1, 2 and 3. You are for 4.
1 and 3 I am.
1 and
For 1 and 3. 2 is the finance department.
2 is finance. Who is you?
I'm for sure.
You are for 4. 2, anybody has seen a finance? D Gogoi, B Gogoi, anybody?
A Chaliha, A Chaliha.
So, okay, yes, I see.
My lordship, if repetitions are came up today, both are similar.
Yes, on list along with he con the similar order to logai disu eta logot kori.
3 repetitions are more there. Those are same with this petition today only. My lordship, when it comes,
Which are those items?
in and 19.
Make it a query. Give the paragraphs which are there and the repetition
My
numbers.
lordship.
Item number 38 and 39. Lord, friend Mr. Devandas also appears from the other side. Of the, who is not informed, can it be on 17th
17th,
of February, Lord? Because this matter is tied up to your lordship's bench.
17th, I may not be here.
Any date when your lordship is there, my lord. I understand there is an outlying bench also. So I'm told from 2nd to 13th.
No, I'm here that
Then,
time.
then it will be very
So I'm
nice.
here during this time. I'm here till the 13th, I'm here.
Actually, President Lordship will be going to Sagirpur, that's why.
In fact, I was, but later on the chiefs changed the roster.
Okay,
Okay.
that is very well, it is to our advantage.
Yes.
Can we have it on 3rd then?
Yes.
Third is there.
Milord, could it be 5th or 6th?
Fifth. 6th is difficult.
Fifth is Thursday. So 5th mile. 5th, sir.
Some family commitment of my management family. 9, 10,
10 is not better.
10th,
yes.
Oh, nothing.
38 and 39. It's at the request of the parties.
At 2 o'clock.
Matters next.
We'll see. I'll also we'll see. I think we'll come in the morning. 11 is Thursday.
I actually fixed this matter on 7th.
Actually,
What happened?
No, it was fixed at 2 o'clock on 6th.
On 6th, yeah.
Then matter went to another court, Milord, when that order was not carried.
Okay.
Because
It was discussed before court number 5, Milord, when you pointed out that this matter was hard in blank, then it was directed to be listened, but that 2 PM thing got missed.
The parties, the learned senior counsels appearing on behalf of the parties
somewhere I'll do it sometime.
have jointly requested that the matter, the 2 petitions be taken up for final disposal on 10th of February 2026. The list this matter on 10th of February 2026 at 2 PM.
Yes.
2 p.m.
Final disposal.
Then, that is in that 2 PM.
Okay. How do you leave it also? Last time.
You filed your reply.
Hello?
You have filed your reply.
Yes, already filed. On my lord, 5th of December.
Yes, what is your case?
The minor issue was that, my lord, there a notification was issued on, my lord, 18, my lord. 18/1/2024, my lord. As per that, my lord, notification, my lord, the secretary directed the bidders, the first bidders to deposit their earnest money within 3 days, my lord. But the response number 6 and 8, they didn't, my lord, deposit their money within that period, my lord. When he came to know, he filed a representation, my lord, on 25th, my lord. This, my lord, name is, my lord. Page 26, annex of 5, my lord. That is the case, my lord.
How much did you quote?
My lord.
How much did you quote?
So, my lord, I was the, my lord, the second highest bidder. As per that notification, if the highest bidder, the first highest bidder didn't, my lord, deposit the money within 3 days, then the offer will go to the second highest bidder, my lord.
You submitted the bank draft
Yes, my lord.
of security money.
I have on me, my lord, in my serial number 3, I was the highest bidder, so I have already, my lord, deposited the earnest money, and they also handed over me the vehicle also, my lord.
It has been given to whom? Prasanto Das and
6 and 8, my lord. Phone number 6 and 8.
there are two vehicles, na?
My lord, okay, my lord. 6 was the, my lord.
One is the Scorpio.
One, my lord.
One is the Scorpio.
And that was not a scrap vehicle, my lord. Though they, my lord, stated in their affidavit in opposition, my lord, not scrap one, my lord. For scrap vehicle, they never, my lord, publish any notification, my lord, in the notification.
So I kept the matter today for dismissal, isn't it? I remember. We'll dismiss it right away. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner, Miss N.R. Sharma or N.R. Sharma?
N.R. Sharma, Lord.
Appears on behalf of the respondent numbers 225.
Five.
225. And Miss M.D. Bora appears for the respondent number 1. The other respondents, however, have not appeared, taking into account that service have not yet been completed. The petitioner herein is aggrieved by the actions on the part of the respondent authorities, more particularly the respondent number 224, 225, in permitting the respondent number 6 and 8 to lift to in permitting the respondent number two to 6 and 8. To take the possession of the vehicle bearing number, registration number AS 16B 6914. And AS 16F 9812 respectively. In spite of the fact that the said respondents did not submit the bank draft, submit the total amount, bid amount,
Bid.
within the period of 3 days, as stated in the
Notification
notice dated
18/1/2020.
18/1/2024.
It's a four, case 23.
Full stop. The case of the petitioner herein is that the petitioner was the second highest bidder, second highest eligible bidder in respect to these two vehicles.
Lordship, only with respect to vehicle number 16 F.
No, 1 and 4.
In case of vehicle number, Lordship, 16 F 905, the petitioner is the third highest bidder.
No.
Mr. Counsel,
Lordship.
did you hear what I said? Was the second highest eligible bidder, because number
Lordship,
2 did
Lordship.
not give the bank draft.
Lordship.
My lord, kindly see page number 19, my lord.
That's
Can it
okay.
suffice, my lord?
Now you are the second highest eligible bidder in respect to the two vehicles. And as the said respondent number 6 and 8 failed to deposit the bid amount within the period of 3 days, in terms with the notice, the respondent authorities ought to have therefore offered the said two vehicles to the petitioner, who was the second highest eligible bidder. Being aggrieved by such actions, the present writ petition has been filed. It is relevant to take note of that this court, by an order dated 28/2/2024, issued notice thereby directing the petitioner to take steps upon the respondent number 6 to 9 by registered post with AD. The materials on record show that the service could not be effected upon respondent number 2, 6 to 9 on account of insufficient address. Be that as it may, the respondent number 3 had filed an affidavit in opposition.
My lord, the petitioner has also filed an additional affidavit, my lord, on my lord 7/4/2025, my lord. Regarding the service of notice, my lord.
wherein it has been mentioned that the respondent number 6 offered the bid amount of rupees 6,11,666. And the respondent number 8 also offered the bid amount of rupees 3,35,501. It was also mentioned that by notice dated 18/1/2024, the final list of bidders of the auction vehicles of the BTC Secretariat Kokrajhar was released, and thereafter by subsequent notice dated 19/1/2024, the last date for submission of the bid was extended to 2/2/2024. So it is pertinent, however, to take note of at this stage that the bid so submitted by the petitioner in respect to the vehicle bearing registration number AS 169805 was rupees 5,51,502, which was 60,164 less than the respondent number 6. Similarly, in respect to the vehicle bearing number AS 16F9812, the petitioner's bid amount was 3,01,102, whereas the respondent number 8's offer was 34,339 above that of the petitioner. It is also mentioned that though the period was extended to 2/2/2024, upon deposit of the amount by both the respondent number 6 and 8, the vehicles were handed over to both the respondents on 29/1/2024, much prior to the last date, that is 2/2/2024. This court have also taken note of that the petitioner have not challenged the notification dated 19/1/2024, whereby the period was extended to 2/2/2024. Considering the fact that the respondent number 6 and 8 have quoted a higher amount and were also evaluated as the highest bidder, and there was an extension given up to 2/2/2024, this court does not find any illegality on the part of the respondent authorities in handing over the vehicles bearing number to the respondent number 6 and 8 respectively. Accordingly, this court does not find any merit in the incident with petition, for the petition stands dismissed.
My lord, that is the point, my lord. The notification dated 19/1/2024, it was manipulated, my lord. For 1 year and half month, they were silent, my lord. When the case was pending before this honorable court, my lord, they never stated before the honorable court that another.
Because the honorable court did not threaten them with a 1 lakh demand. The day I said I am going to impose a cost of rupees 1 lakh, then immediately they can.
Notification, my lord.
Yeah.
Everything is in the hands of the my lord, the respondent, my lord, not in the hands of the my lord.
Yes, what is this?
No, what is the regarding these water case, my lord? There is no any application, anything, but he was selected. So I tried it, my lord, and he was passed order. And in order, my lord, in paragraph, this 12, so can see of IL, my lord.
Was regards the mark of D in the voters list in respect to LAC's 47 Senga village so and so to be the competent in Borpeta. Now, what is wrong with it?
The typography, they, while drafting the writ petition, they made an error in paragraph 5 the writ petition, lordship. There they have written that it is LAC 47 Senga. And again, while annexing the voter list, lordship,
Yes. No, I was annexed that we were.
they have also annexed the voter list, lordship. But again, while submitting the translated type copy,
Page 14, that is, it should be.
again in the translate type copy of the voter list of Borpeta, while translate type copy, they have again written 47 Senga. This because of this error has occurred in the order, lordship.
But in the summit particular, of course.
Okay, no problem. We allow your petition with a cost upon Mr. A receipt of 10,000 for spoiling the unnecessary time. Not upon the petition, upon you. No. Heard Mr. A receipt the learned counsel appearing on behalf of the petitioner and Mr.
Yeah,
A Ali appears on behalf of
it's 105.
the Election Commission of India. The present application has been filed seeking modification, seeking certain, seeking review, seeking correction of the order dated 28/2025 passed in WPC number 4707/2025. Full stop. It is the case of the petitioner that inadvertently at paragraph number 5, it was mentioned that the petitioner was marked as with the letter D in the voters list in respect to LAC number 47, Senga village Dhamoldhar in the district Borpeta. Whereas it should have been
Borpeta.
the voters list in respect to LAC number 43, Borpeta village, Kahibari, district Borpeta. The learned counsel appearing on behalf of the petitioner submitted that on account of the translation of the voters list, this error had crept in. Resultantly, a mistake was committed in the order dated 28/2025. So this court have also perused the records of WPC number 4707/2025, and upon a perusal of the vernacular version of the voters list, it is seen that the petitioner was marked with the letter D in the voters list in respect to LAC number 43, Borpeta village, Kahibari, district Borpeta, and not in respect to LAC number 47, Senga village, Damaljar, district Borpeta. Accordingly, this court therefore disposes of the instant application by making correction to paragraph 5 of the order dated 28/2025, thereby the words, inverted comma, the petition, the mark D, inverted comma, in the voters list in respect to LAC number 47, Senga Village, Dhamaldar, District Borpeta, inverted comma, close, be read as the mark D in the voters list in respect to LAC number 43. Borpeta village, Borpeta, comma, village Kahibari, district Borpeta. Puts- The instant order shall be a part of the order dated 28/2025 passed in WPC number so and so. I sense disposed. Okay, hearing no motion with the take. Motion. No, motion. We'll have the motions first, not now. There are a lot of other motions which are there.
Challenging the rejection of his candidature by the review medical board. The recruitment process here was conducted by the SSC for the constable TP, PF. He has passed his written examination and physical efficiency test. And that when the detailed medical examination has been conducted by the SSB on 24/11/2025, he is declared unfit for the 3 reasons, which is page 30.
Where is the opinion of Tezpur Medical College?
In the review medical board, which is annexed page 33. Review medical examination has been done on 27/11/2025. The first, regarding cardio mainly the special doctor of
Color vision you have. You have color vision.
Yeah, but as per the guidelines and the rules made by the equipment board, Your Honor, the required super specialist doctor has been examined, which has been done in part in my case in cardiology.
Huh?
In cardio, it has been checked by the special doctor of the Tezpur Medical College Hospital. But wherein on the color vision defective, there is no such special doctor has been taken into account while conducting the entire test. More so, Your Honor, the entire examination has been done in the evening hours, which has been again violating the rules of the by the SSB, Your Honor. I have annexed the rule, page 451. No candidate has been rejected unless it is stated in a broad deadline. But in my case, Your Honor, while the entire exercise of the examination has been conducted by the SSB, Your Honor, my case has been conducted at the late evening hours. But that too, without any specialized doctor has been taken into account for the opinion. That is why I prefer challenging this entire review medical board examinations report, Your Honor, on the basis of those grounds. First of all, in cardiology, there is a specialist doctor has been opinions been taken out. But in eye defective for color visions, there are no such.
One disease is enough, or you need 2 diseases?
My unfit for the 3 reasons: for cardiology, hypertension, and the color vision. In the review examination.
What is your age?
22.
So 21. With 21, if you are having pressure of 130/80 or 150/92, it doesn't seem to be proper.
That review medical examination has been declared that it is preferable and within the limit.
Where?
In review medical report, I have annexed in case 33.
Regarding cardio, medical CIB physician, Final no chest, no so and so. Significant abnormality unfit on account of regarding BP 130 by 180, 130 by 180, 120 by 74, 112 by 64 within permitted limit.
In color vision, your lordship, since the entire exercise has been conducted by the medical board at a late evening hours, that too, without taking into account of the opinion of the expert. Wherein in the cardiology department,
So you have taken an opinion of the expert.
yes, later on I have visited.
Where?
NXS G, page 36, Tezpur, I have myself conducted a test in Tezpur Medical College Hospital, wherein the said ophthalmology doctor has been declared me I am fit for any kind of color vision.
So after this, did you approach?
Yes.
When?
On 4/12/2025, after declaring the unfit by the review medical board.
So
I
did you approach them again?
No, I approached myself to the medical college hospital.
No, this happened on 27/11. Did you approach thereafter on 4/12 after that?
Yes.
When?
On 4, I Tezpur Medical College. Hospital.
After that, did you approach them? Chalo, hey, kon AM Khanon is dispose for you. 10 days, submit your representation, giving all these documents, and they will consider that.
Item 1 for good.
Your matter is Sweta Bhattacharjee. Okay.
Where please, your lordship. Lordship, this writ petition is against the illegal and arbitrary transfer order dated 02/01/2026. I'll draw your attention to annexure 1 at page 26.
Why should this court, you were posted in Guwahati?
No, I was posted at Namsai. I was at Guwahati to look after my ailing mother.
No. This court would not exercise the jurisdiction because none of the respondents are here. None of the respondents are here. One respondent is in Rishikesh, the other is both 3 Rishikesh and one is in Arunachal. Why should this court exercise the jurisdiction?
Lordship, I am a resident of Guwahati.
You can't be a resident of here. Considering the fact that you were posted out there.
Lordship, I was on approved medical leave, and this has come during the period of my leave when I was at Guwahati, and it has come through WhatsApp, interestingly. So basically, Lordship, I was looking.
Where's the
after-
transfer order?
Annexure 1 at page 26.
2/1/2026. What is this company?
It's a company.
What company?
It is THDC India Limited.
What is that?
It is a PSU.
Huh?
It's a public sector undertaking. THDC India Limited.
What do they do?
They are looking after the power sector, basically hydro power projects, etc.
They have no business out here. You have no case.
Lordship, this is also against the, I would draw
You are doing your work is in Namsai. You have a problem in getting transferred from Namsai to Rishikesh, you are having a problem.
Because I could not leave my ailing mother, so I am here.
Make a representation. Have you submitted a representation? Then
The
where?
Representation has been submitted. In fact, there have been 2. I'll draw your attention now. Annexure 1, Annexure 11 at page 56. Second representation, Annexure 12 is at page 58. And Third representation, annexure 13, page 61.
You have a
Fourth
flight to
representation,
Dehradun nowadays.
Lordship,
There's a flight to Dehradun.
there is, sorry, Lordship, this is at Rishikesh, and she has to look after her ailing mother. Otherwise, she'll have to lose her job. And secondly, Lordship, this is arbitrary and it is discriminatory because she was told that I will draw your attention to para 10 at page 8.
Huh? Age?
Lordship, this endowment, girls should remain at home. We are living in the 21st century.
Ah.
And comments like, I would not have sent my daughter to such a part of place. We are living in the 21st century and this is the mindset. And why it is also against the transfer policy of the other state. The transfer policy, I'll draw your attention, Lordship, to annexure 2 at page 29. Para 6.1. The normal tenure of posting will be 5 years for executives. 5 years. And she has not even completed 2 years. Second, 6.2. Minimum period of 5 years at one location.
When did you join this company?
I joined this company in 2023 January. I have completed 3 years. My first posting or transfer was at Pipalkoti. Then the second transfer has been here, which was done in January 24. So I have just completed 2 years out of this, and they have their own guidelines says minimum, not even minimum 5 years. And why I say Lordship,
In normal course.
in normal course.
In normal course. You had no problem in the transfer from that people court to Namsai.
My mother was 80.
No. I'm asking you, didn't you have a problem when you were initially appointed in 1 year you were transferred to Namsai, you had no problem? You
Lordship,
cannot raise this issue.
no, Lordship, that period is a training period. So actually, I have been in the job for, this is my first posting, if you exclude the training period. Why I say it is, in fact, if I look at similarly situated employees, there are 6 who joined together, 3 boys and 3 girls. 2 girls have already left. I am the only girl who is still staying
Where?
in this company.
Don't remain. Leave it.
Lordship, in this 21st
I am
century,
not, Mr. Counsel, I make it very clear. I'm not interested. This court is not inclined, first of all, to entertain this petition here. First of all, the company is at Rishikesh. Your posting is at Namsai in the state of Arunachal Pradesh. Nothing to do in Assam, except your mother stays here.
Other states, I am a permanent resident. and
No,
I-
you are not. You are transferred out there. You are there.
Lordship, if I may be permitted, I am a permanent resident. I have received this transfer order when I was here, when I was an authorized leave. And it is against the company's policy. So, Lordship, and she is seriously ill. Otherwise, I would not have been, my mother is seriously ill.
But take leave.
The leave also they have not granted.
Where is it?
Lordship, I'll just say. Annexure 15 at page 64. I have exhausted all this. 4 applications. one
Annexure?
year At annexure 15 at page 64.
Yes. Now, leave application can be submitted to recommending officer, but the final approval should be the DGM or above.
I have exhausted all my.
Where's the leave application?
This is the format which is followed. It is specifically given that from, like they say, from 1801.
Have they rejected the leave?
They have not responded at all despite 2 reminders. If you see annexure 15 continues.
Now, leave application can be submitted to the recommending officer, E2 or above. But the final approval should be given by so and so.
So I have to give it to my officer and he submits it. That is the channel which, so I have given it. I've sent a reminder.
Hmm.
So
What is this annexure 16?
same leave application, and it is from annexure 16 is this thing. I have applied for leave on, if you see the second last line, Lordship, I have applied for leave. I have intimated also. They said, okay, and that is all. No response. As a young girl of 28 years, what do I do?
Go there. Simple.
Lordship, we come to
You, why did you first join a job out there where these people are, where's your appointment letter? Let us see.
Lordship.
I would have understood that you want to stay here in Guwahati. You want to stay in Namsai. So Namsai and Guwahati is same 500 kilometers away.
Exactly.
Then-
That is why I can look after my.
How?
Because I can come, because it is such a short distance. Sir.
No, Dehradun is nearby.
Dehradun, Rishikesh, I have to either go to Dehradun, Dehradun to Calcutta, Calcutta to Guwahati.
Huh?
Rishikesh, I have to go to Dehradun or Delhi. Thereafter, I have to come to, if I go to Dehradun, Calcutta and Guwahati.
No, here you can go to Dehradun.
And then come to the distances and.
You go to Dehradun, from Dehradun,
Like you.
Dehradun is nearby.
Like you mentioned.
Rishikesh.
It-
Not
More
satisfied.
importantly, Lordship, they have violated their own rules.
No, there is no violation in normal circumstances.
But it has to be, it is for similarly situated individuals. There have been my batchmates who are staying at one place from the time they have been there. Both males, they have stayed. Girls, 2 girls, they have left. I'm the only one left and I'm being shifted. So I also, for a similarly situated this thing, I also want that, yes, I should also be treated similarly. My submission is I should be treated similarly, and Lordship, in fact, I have specifically given that I do not even want the cancellation of the this thing. I have requested for holding in abeyance just for a year
Why?
for my mother's this thing.
Should be okay by one way.
That means
Rishikesh is good. They have good, you have a Ramdev out there nearby. Get it done.
her mother won't be able to.
Ah, Ramdev is nearby.
But
Get
Lordship,
it
the
done.
main grounds is that
You
the
could,
company has gone against its own policy, which is on paper.
no, Mr. Bhattacharya, I have a big problem out here regarding the jurisdiction.
And
This court would not like to exercise its jurisdiction unless you take the approval from the Chief Justice. Because this court, why should this court do it?
Lordship, because my reasons, Lordship, is because
Unless if I would have not given you the permission in the morning, then this matter could not have been filed itself. They would have asked you.
Lordship, I have deeply thankful for
Take
this
the
thing.
permission from the
But-
Chief Justice. Because otherwise it is there before the year.
Similarly situated people.
No, all said and done, looked into, first of all, you are aware, transfer is a very difficult job to pass an order of stay, one. Mr. Bhattacharya, I'm more concerned about your person. The moment, if I don't issue a stay, she will be terminated. This is which is going to happen. And I am not inclined to grant a stay.
Lordship, that is the submission.
I know that.
have to leave her job.
So better leave the job only. I think better off. First of all, either staying in Namsai is a bad place.
When something illegal is there, when the
No,
company.
illegalities are there, but I don't have the jurisdiction.
Lordship,
You see,
Your-
after the Reorganization Act, when the order by which the Arunachal Pradesh has a high court out now, it will be there. Not here.
Lordship in the interim, Lordship in the interim, in case you can give us stay and give us time to appeal in the Arunachal bench. In case.
Huh? When I don't have the jurisdiction, how do I do it?
Because she is in such a position.
Let me do one thing.
Sir,
I'm not going to pass an order. I'll place the matter before the registry to move the Chief Justice, along with an application to be filed before the Chief Justice for permission to move it here.
Lord-
Then only I can permit it.
Lordship, Lordship.
Otherwise, I'm not going to pass this. Heard Mr. D.S. Bhattacharjee, the learned counsel appearing on behalf of the petitioner. The petitioner herein have assailed an order, a transfer order issued by the respondent number 1 dated 2/1/2026, whereby the petitioner has been transferred from APP, Arunachal Pradesh to LNA Rishikesh. And the petitioner was directed to report to the CGM HRNA Rishikesh for further orders. It is relevant to take note of that all the respondents the respondent numbers 1, 2, and 3 have their addresses at Uttarakhand, in the state of Uttarakhand. And the respondent number 4 has its office at Namsai, Arunachal Pradesh. It is also a fact apparent from the records that the petitioner has been transferred from Namsai in the state of Arunachal Pradesh to Rishikesh in the state of Uttarakhand. Under such circumstances, it is the prima facie opinion of this court that the instant writ petition cannot be permitted to be, no orders can be passed in the instant writ petition. Since an authority being given by the Chief Justice, by the Honorable Chief Justice, thereby permitting the petitioner to move the writ petition before the principal seat. Mr. D.S. Bhattacharjee, the learned counsel appearing on behalf of the petitioner, expresses urgency. Considering the above, the registry shall list the matter, and the registry is directed to move the Chief Justice, Honorable Chief Justice. Additionally, liberty is given to the petitioner to also file an application before the registry, before the Honorable Chief Justice, seeking permission to move the instant writ petition before this court, before the principal seat. Taking into account the urgency expressed, the registry shall forthwith take appropriate steps.
Much.
And Mr. Bhattacharjee, there should be something written about that company, that it is a state and all. Nothing is there. Seems it is because of the urgency, all these things have not been put. But it becomes very difficult for this type of company. Anyway, yes.
The petitioners have been
What are these? 16 petitioners, what do you want?
It's only, they are only one, they only wanted the pay scale, my lord, as per the order or as per the judgment.
To regularize the services as fixed pay workers considering the length of service rendered in so and so. What is this? What is your prayer?
There is, my lord, only the pay scale should be in the light of the judgment, my lord, Bhupen Das, state versus Bhupen Das, my lord. Wherein they have stated.
But Mr. Counsel, what is your prayer?
Minimum pay
No, no, Mr. Counsel, read page 29. Directing the respondents to regularize the services of the as fixed pay workers.
Fixed.
What is this? You are asking for something which is against you. You should have asked that directing the area to pay you the minimum of the scale of pay given to the last. This is not your prayer. This is a very dangerous thing which you are asking, Mr. Counsel, isn't it?
Yes.
You are asking that you give me a fixed pay.
Sometimes they have given,
Huh?
sometimes they have,
What will sometimes?
some of the letters of the government, my lord, they have only mentioned like this, like.
They mention as fixed pay because you are to be given 700 or 1000 or 1500. But what you want, what is given in the case of Upendas, that is persons who have worked for 10 years prior to 8/6/2017 should be given the minimum of the scale of pay. Where is it? No, Mr. Counsel. File a fresh one.
Pay scale, although I have read, my lord, it's a.
No, no. You see, the problem which will happen is tomorrow because of you, because of your lethargy, because of your fault, the petitioner would not get what it is. You know, these type of orders, when the court passes, the first thing is they don't like it, they like to file an appeal and see the prayer. Tell me, I can issue a notice, but the fact remains tomorrow, they'll ask for that what you are asking is a very dangerous proposition for yourself. You are asking that kindly keep me fixed. Isn't it, Mr. Bothagar?
If they are regular, they cannot be fixed pay workers. It is contradicted.
You ask them, they regularize me as a fixed pay. Withdraw and file a fresh one. Amendment. Then what are you going to do? That amendment will be allowed. Okay. So how many stages you go? You will file an amendment petition. It will come up for orders. It will be then listed. Then it will be allowed. Then you again file this whole petition. Are you not required to file a fresh new petition? Amendment petition allowed would not make it. You have to file a fresh writ petition. So why are you not withdrawing and filing a proper one? Yes. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that there has been an inadvertent error in the relief sought for in the writ petition, and as such, the petitioner would like to withdraw the instant writ petition with a liberty to refile by removing those formal defects. Mr. Aibot Thakur, appearing on behalf of the respondents, has submits that he has no objection as regards the prayer for withdrawal and with liberty to refile. Taking into account the above, the instant writ petition stands closed on withdrawal. Because the liberty is given to the petitioner to refile by removing the formal defects.
All right.
FA law score, where is he? You are FA law score.
My lord, he is under treatment due to lots of dialysis things.
Huh?
So he requested me to adjourn the matter.
Adjourn the matter. Okay.
This is also same, my lord, same.
Where is that other council, the earlier council? He should have the relief like this. At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after 4 weeks.
Yeah, since the implementation part. Yes, section 3 in the implement, action taken report is also to be submitted.
What is the value of a report?
Yes, that's should,
Because you are asking a writ. Why should I issue a writ? On the basis of a report being submitted? If the assembly has not accepted the report, once the assembly accepts, the report gets the flavor or has some legs to stand.
that model government may. The government may civil society. But so far my.
Government is not going to help you. Are you asking the government to help you?
Knowledge is concerned, will not, it is accepted by the assembly.
Hmm?
Action taken report is not submitted along with
Then-
the report.
How can I issue a writ? To me,
The similar case will not include.
yes, Mr. P.K. Roy, you are busy with another matter. A report submitted by Commission of Inquiry has no legs to stand unless the Commission of Inquiry report is accepted in the Assembly. Once it is accepted, then the court can exercise 226 at best.
Right. That has to get.
First, it has to be accepted in the Assembly.
Exactly.
But what
It's,
happens
it's only a
as regards those
recommendation.
other-
my lord.
Huh?
It's only a recommendation. my lord.
It's only a recommendation.
In 2013 also the same, so for my knowledge.
So
it will be
therefore, my
accepted.
question is, what happened to those matters where Justice Surana has passed the judgment? The division bench judgment?
That was in the service matter, Lordship.
Suspension and,
The discharge of.
No, the suspension, was it on the basis of the Justice B.K. Sharma's report?
No, Lordship.
before that, Lordship, first challenge was, not on the report, Lordship. The second time this, report was challenged. Initially, they, because of, this things, disciplinary actions that has been taken, Lordship, by the authorities.
Lordship is also correct in some aspect. The what happened, Lordship, initially that accused persons who were arrested in connection with Dibrugarh PS case 936 of 2016, Lordship, they were discharged from service. Their contention is that some of them were acquired.
But that is not based upon,
No, B.K. Sharma report, not based upon B.K. Sharma report.
Later on, this has been.
Later on,
carried on, Lordship.
Later on, after submission of B.K. Sharma report, Lordship, based on this B.K. Sharma report, some notice were disciplinary, so-called notice were issued to certain candidates, Lordship.
but how can the notice be issued on the basis of that report unless that
That
report has
so-called
been
notice-
accepted in
so-called-
the
so-called
assembly?
notice Start, you said, whereas as per the report of the B.K. Sharma commission, you have done so and so illegality. And that report, that so-called notice was put into silence before this court and a series of petition is still
And
pending.
there must be a stay, most probably.
Yes, stay.
Rightly so.
Yeah,
It has to be because that report has no value unless it is accepted in the
Right.
assembly.
That is one aspect. Another aspect also, that is all the fact finding report.
That's right.
Understood. But then also, you see, for this court to issue a writ,
It is like a preliminary.
some legal basis has to be there.
Yes.
Exactly.
Tomorrow, just for example, you have the 8th pay commission coming in. 8th pay commission gives a recommendation, okay, all these people's salary should be increased and all. But unless the cabinet and the parliament accepts it,
It becomes a rule then.
It
then
becomes a rule.
the rule. But here it has nothing, so his case is premature. Just filing the case with so big petition. Environmental degradation.
I have been accepted by the assembly, but I do not have concrete,
Take your instruction.
but it may take it as once.
At the request of the learned counsel for a petitioner, list this matter on 16th of February 2026.
The matter is come up with the office note, Your Lordship. On the last occasion, the order was passed to file an amended writ petition, which has been filed yesterday, Your Lordship. But it has not come on before.
You have filed the amended petition.
Yes, sir.
When did you file?
Yesterday we had given for the filing, but today it seems like it has come.
Wait, I consult. Yet IAS.
The order was passed on 5/1/20.
7 days time.
Yes, Your Lordship, after that.
When did you file?
Yesterday.
Huh.
Your Lordship, vacation.
We have to reject your amendment application.
7 days.
The amendment has to be rejected. Because of the fact that you had to file within 12/1/2026. You filed it yesterday. Hardly matters. 7 days is over, and if you see the Limitation Act, then it will be in the next date. I never say the only 7 working days. So we dismiss your petition on that ground. Yes.
It's Your Lordship.
Huh?
On merits, Your Lordship.
Merits only, I'm dismissing it. What do you say? Argue. On the basis of the earlier petition, you disregard the earlier petition, this petition. Argue now. What is your case?
The matter was
Selection to quash the selection of the respondent number 5 as Gao Pradhan of so and so by the advertisement dated so and so. Why ineligible?
Your Lordship, there, as per the advertisement, there were some eligibility criteria, Your Lordship. So as per that, according to our contentions, the respondent number 5 is ineligible. If Your Lordship comes to page 28, Your Lordship, the advertisement.
Yes.
Next page, Your Lordship, serial number 6. It is stated that preference for appointment will be given to the family members of Gao Pradhan, and in this regard, the opinion of the Mauladar will be taken into consideration. Second, point number 7, Your Lordship, the applicant should not be a government employee. And third, point number 9, Your Lordship, the applicant should not be a member of any political party. So, Your Lordship, in this regard, appeal was also filed before the appellate authority. The order has been passed on 1/8/25, which is at page number 80, Your Lordship. And it is a 14. Page 82, the relevant part.
Who is the appellant? Appellant is Hatem Ali.
Yes, sir.
Who is respondent number 5?
Bilal
Hussain.
Singh. He secured 32.66 marks, and the petition was given 28.33 marks.
Hello, bad case, we dismiss it.
If your lordship may come to page 80,
I've read the order. There were 3 grounds.
yes, sir.
So first ground is that you were not given marks. You got 10 out of 10 in respect to the relation aspect. Whereas he did not get any marks.
Yes, sir.
Number 2, your consideration was as regards he is a government employee. There's nothing out there that he was a government employee.
Yes, sir.
Number 3, it's a finding of fact. Number 3, he was a political partnership, party membership. He has already resigned as on 15/12/2018
Regarding
from primary membership, and there is nothing out there.
your lordship, regarding that, at page 34, we have annexed the document which shows that he was a party even during the application of the appointment
Where?
advertisement, your lordship, at page 34.
What is that? The Dhing Revenue Circle Head Association wishes to submit Abdul Majid of so-and-so has stepped down from the village as so-and-so. Where's the BJP?
Annexure 12, your lordship, at
Huh?
page
Annexure?
12.
You are reading from the amended petition. Don't read it from there. That has not, I'm not going to accept it.
Page 64, your lordship.
Page 64. Who has issued this?
Your lordship, next page is the vernacular, your lordship. It is in the pad of BJP only. Second paragraph, to my knowledge, Mr. Bilal Hussain has not till date formally resigned from the BJP party and as of today continues to carry out party-related work. And in the above para, it is also mentioned that he contested in the last panchayat election, your lordship, which confirms that during the
When did
exercise-
he contest?
It is mentioned in the first para that he was, he contested on the last panchayat election.
Where?
First para at page 64.
Who is he? This person?
This person is somebody from BJP of your political party.
No, this finding of fact, bad case, we dismiss it. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner.
One judgment also.
A judgment is for division bench. Mr. S. Dutta appears on behalf of, yeah, you should know what to do then. Mr. S. Dutta appears on behalf of the Revenue Department of the Government of Assam, and Miss So-and-so appears for the respond number
3 and 4.
3 and 4.
2, 3 and 4.
2, 3 and 4.
This matter also is a similar kind of measure. Your lordship may-
Not bound. The petitioner herein have assailed the appointment, the selection of the respondent number 5 as the Gaon Pradhan of Raumari village under Batadrava Muja of Dhing Revenue Circle in the district of Nagaon, Assam. Full stop. It is relevant to take note of that pursuant to filing of the instant writ petition, the petitioner filed an application seeking amendment of the writ petition. Thereby to include thereby to challenge the impugned order dated 1/8/2025 passed by the Director of Land Records and Survey Assam, and also for stay of the said order. This court, by an order dated 5/1/2026, allowed the amendment and directed the petitioner to file the amended written statement, writ petition within 7 days. Full stop. It has been submitted that there was no amended written statement writ petition filed within the time so permitted by order dated 5/1/2026. Under such circumstances, the amended writ petition cannot be accepted. Full stop. The challenge to the selection of the respondent number 5 is primarily on 3 grounds. First, that the petitioner was not accorded marks as per clause 6 of the advertisement dated 5/9/2022. Secondly, the respondent number 5 was a government employee. Working as an assistant teacher at Romari Muhammad Ali High School. And the third is that the respondent number 5 is a member of a political party, that is the BJP. Bharatiya Janata Party, back in BJP. Full stop. This court had duly taken note of the order dated 1/8/2025, which is an appellate order passed by the Director of Land Records and Surveys, wherein these 3 contentions were duly dealt with. A perusal of the said order dated 1/8/2025 reveals that the petitioner was granted 10 out of 10 marks on the aspect pertaining to family preference, whereas the respondent number 5 was not granted any marks. On the second question, it was found that it is a finding of fact arrived at on the basis of a report dated 18/2/2025 from the headmaster of Raumari MA High School, forwarded by the Inspector of Schools NDC Nagaon on 24/2/2025, that the respondent number 5 resigned from his teaching position on 8/2/2022 prior to the advertisement. Under such circumstances, the question of the respondent number 5 being a government employee does not arise. The third aspect, third ground so taken was that the petitioner, respondent number 5, was a member of a political party, that is Bharatiya Janata Party. A perusal of the order dated 1/8/2025 further reveals that the respondent number 5 had resigned from the primary membership of the BJP on 15/12/2018. And this very aspect was substantiated by a clarification letter dated 5/8/2023 from one Bipin Bora, President BJP, Botodrava Mondal, confirming that the respondent number 4 ceased to be a member with effect from 15/12/2018. Under such circumstances, this court, therefore, does not find any perversity in the said fact-finding inquiry to entertain the instant writ petition. Accordingly, the writ petition stands dismissed. Bless you.
53.
Huh?
I was dismissed from service, Lordship.
Why?
Lordship. And case came
When
to
you
my
have a
attention.
counsel like Mr. MP Sharma, why is he dismissed from service? Order or direction of like nature setting aside the show cause notice. Then what happened?
Suffered
You were
from-
dismissed in the year 2005. Now what happened?
Now, Lordship, I preferred an appeal, Lordship, that is pending, and my subsistence allowance for the period, Lordship, that has not been paid, Lordship. So,
You were dismissed from service.
yes, Lordship. I was dismissed, but I remained under suspension with effect from 5/11/99 to 25/4/2005. For that period, I was in service, Lordship, and
Now what do you want?
for that period, Lordship, subsistence allowance is required to be paid, Lordship, and
What about the others?
that appeal, Lordship, that appeal is still pending, Lordship.
When did you file the appeal?
Since 2025, Lordship. The date is
You were dismissed on 25/4/2005. You filed an appeal in the year 2025.
handled that, Lordship.
And Lordship,
What?
I have received one instruction also, Lordship, that as has been contended by the petitioner at Annexure 6 that he has preferred an appeal, there is no any record of any appeal, Lordship, received by the concerned. This is the instruction from the Assam Police Headquarters, Lordship. No such appeal has been preferred, Lordship.
In the meantime, I approached Lordship, but then the documents were not given to me. And although Lordship, the criminal case was pending, that was decided in 2019. Lordship, in the meantime, if I representative stating that Lordship, this departmental proceeding may be kept in abeyance till the criminal should be decided.
You are suffering from stomach pain from 2002, 2003. Huh?
Lordship,
Blood dysfunction, jaundice.
that was
Then
there, Lordship.
joint pain,
The third handwritten one, Lordship.
loss of memory.
Yes, Lord, that there, Lord.
That was only from 2000 to 2003. Thereafter, now you are fit and fine.
No, Lordship, I prefer the representation stating that, Lordship, till the criminal.
No, tell me, now you have full memory.
No, Lordship,
Huh?
still not fully, if Lordship, but then. I
What?
will be- To resume your duties, Lordship, you will be able, Lordship.
Now tell me, you don't have any memory, but you have filed an affidavit. In the affidavit, how are you stating the facts? Tell me.
Lordship, I prefer an RTI, Lordship.
Understood. Oh, then you had the memory. Something has to be there. Because in the affidavit, you say there are statements made in paragraph are true to my knowledge. Knowledge, not even on records. How do you take care of that if you didn't have memory?
That was there, but then
That is the only there.
there was an order. Since the charges were such, Lordship, I was alleged to have committed.
How on earth do you get this type of things, cases, Mr. Counsel?
Lordship, the other persons who were charged along with me, they are serving, Lordship. The other persons who were charged along with me in the criminal case, they are serving under the department, Lordship.
Were you not convicted? What is this conviction order? There's a conviction order, judgment
Lordship.
in the
Section
page
4.
21?
Page 24, Lordship. they can-
Huh? You was convicted?
No, Lordship, page 24.
I say, I arrive on the conclusion the prosecution has failed to establish a case. Okay. So there is no case against you. So why were you, the disciplinary proceedings was initiated against you?
Basing upon these allegations from
Huh?
Lordship, the so called, it's a page.
No, no, no.
Like, it's-
Bad case. How did you participate in the trial? Tell me. Then also case went in your favor. Huh? How did you participate? Tell me. From it was going from 99 to 2019. How did you participate?
In Lordship, in portion, I.
Got your memory back. Chala. The only thing I can do is adjourn the matter today, not to dismiss it today. That's all. I will fix another matter on second. I was supposed to be not there. So on that day, I'm dismissing that petition along with this one together.
But the subsistence allowance, Lordship.
Subsistence allowance, you'll get it.
Lordship.
Who is to pay the subsistence? You are for which?
Lordship, I'm for the I'm for
Get your
the
instructions
respondent,
on that
Lordship. Yes,
subsistence
Lordship.
allowance.
Yes.
Others,
Lordship,
other
even-
thing you have no case.
Yes.
They say that they did not.
No, that is a lost cause. Subsistence allowance, if you have not got it during the period of suspension, you have to get it. That is your due. You will get it. You get it. Don't worry. You get your instructions on second. List the matter on 2nd of February 2025, 26.
Keep out.
Instruction for the library. Right. What is this?
By last order, my lord, respondent, instruction.
What is the prayer?
The only.
Name of the petitioner shall not be forwarded. Forwarded for what?
I am working under military department. I was working, my lord, from 1985.
Yes?
As my lord, field worker, my lord.
And then?
DDP spray, my lord. Subsequently, my lord, restaurant number 3, my lord, issued a notification that is annexed page 20, my lord.
20. Okay. You are hereby requested to submit the list of so-and-so say DJ who have been working more than 10 years in DTSP spray operation of so-and-so. Please note that the above required information shall reach the airport hard copy on so-and-so. So your name was not sent.
Not only my prayer. What happened, my lord? Why my name is not sent, my lord? Earlier, my lord, whatever is BPSC.
No, why the name is to be sent for regularization?
My lord, that is up to the respondent, what the government will decide. I don't know, my lord. Only I will be satisfied if my name is sent to the restaurant number 3, my lord.
Send the name.
Otherwise,
Don't do anything. Only send the name. He is
What
satisfied.
happened with the other candidates?
Others forget about that. You are only satisfied by sending the name.
Yes, Lordship, that is his only prayer. Otherwise, seasonal worker, Lordship.
Seasonal worker, and how many years? From 85 to 2025 is 40 years.
No, Lordship, till 2007 he worked. 2007 he worked. After that, he never.
No, it was my lord, brought to my lord. Now that scheme was not exist, my lord. In the year 2007. my
Now
lord,
what is there to send the name?
My lord, only that notice that those who workers working.
Therefore,
more than
forwarding
10
the
years.
name of DTC so-and-so. I've been
And
serving for
this
20
is a-
years from 2005 in so-and-so. Under the Iman, it is mentioned the health department published a notification seeking the names and addresses of candidates who bear such experience from
2024 notification. Lordship.
Will obtain, although notice has not been issued, extra copy. Yes, what is your instruction?
Lordship, not received, Lordship, any.
But what benefit you are going to get if the name is sent? Tell me.
That is all I am not aware.
Don't aware, I'm not going to issue notice. You have to know what is the benefit. Should the court issue writ just for the sake of it?
My lord, only I heard that government is going to engage my lord. All those.
You have lost your engagement from 2005. 20 years has already gone.
Yes, but
Then,
government, my lord, issued that notice. but
no. You are not working from 2007, na?
Nobody working 2007.
Then-
Scheme is closed, my lord, but
Then-
suddenly they have revived that scheme, my lord. This is the scheme. Government, my lord.
No, they did it not because of that. It must be given the last pay wages or like Upennath, something like that. But you are not working, it is not OER. Anyways,
The person,
this court inquired with the learned counsel appearing on behalf of the petitioner as to what benefit the petitioner would get if his name is forwarded in terms with the communication dated 9/4/2024. More so, taking into account that admittedly the petitioner is no longer in service from 2005 onwards, and 2 decades have passed in the meantime.
from 2007.
List this matter. You say at page 21, 2005. I never said so.
At page
17 also it is
My lord, at
2005.
16, my lord.
Huh?
Page 16, my lord.
Page 21, page 21.
Page 2.
List this matter, another dismissal on 2nd, huh? List the matter on 2nd of February 2025.
Highly obliged.
55. You just inquire why that was not.
Yes, Lordship.
Petitioner has challenged the rejection of his candidature because of non-production of the OBC NCL certificate.
Which one?
Because of non-production of OBC NCL certificate.
You challenge this as I asked you.
Here the issue is slightly different.
Oh, what?
At page 90, you must have find. He has got a certificate in the format of Annexure 7. He has obtained a certificate in the format of Annexure 7, which is the requirement of the respondent, on 10/9/2024, Lordship. Crucial date is 14/10/2024. In spite of that, Lordship, his candidature was rejected. At page 90, your Lordship will find that certificate.
But this certificate was there.
Lordship,
Then they rejected. Why?
page 91 is the rejection. Same ground, Lordship, as on 14/10/2024.
As on date of Iman not produced due to which year? No, so do you say that this rejection date, the reason is wrong?
Lordship.
So the question is as to whether this particular document at page 90 was at all produced
Yes, Lordship.
when the verification was made in terms with clause 6.1.
Yes.
That's it?
Yes.
You find out?
Yes, Lordship, I have received instruction. As per my instruction, Lordship, the validity period 14/10/25 is not mentioned.
Huh?
And still, I have received an instruction, Lordship.
What is that 1410?
14/10 is the crucial date for producing the.
Yes,
It is
Lordship.
1410 is the last date, the closing date as per 6.5.
Yes,
Now, his certificate is dated 10/9/2024.
yes. Lordship.
So therefore, you obtain instructions and file your affidavit, okay?
Yes, Lordship.
Because here there might be many other things. It may be a fact that this certificate may not have been issued at all.
Yes,
Because otherwise, what you are saying is that this certificate was not produced, as you can see at page 91. Heard Mr.
The
issue
instruction
notice.
also says that this certificate was produced. The instruction also says that this certificate was produced. I have just seen.
Okay, issue notice making it returnable. How many petitioner?
Only one, Lord.
Okay, issue notice making it returnable on how long? 2nd of March.
Yes, Lordship. Yes.
2nd of March 2025. 26. Ms. S. Borwa accepts notice on behalf of all the respondents. All
Yes, Lordship, all.
the respondents. Extra copies of the writ petition be served upon heard by tomorrow. The petitioner herein is aggrieved by the rejection dated 2/12/2025 on the ground that the petitioner was not entitled to age relaxation as the petitioner had not produced the OBC non-creamy layer certificate as on dated 14/10/2024. So, the learned counsel appearing on behalf of the petitioner submitted that a certificate dated 10/9/2024 was produced, which is at Annexure C to the writ petition. At the time of verification, in terms with clause 6.1 of the notice dated 5/9/2024, he therefore submits that the impugned rejection dated 2/12/2025 suffers from perversity and gross illegality. Full stop. Ms. So-and-so, the learned counsel appearing on behalf of the respondent submits that she would obtain instructions and file an affidavit. So this court also heard the learned counsels on as to whether there is any requirement for passing of interim directions. And it is the opinion of this court that taking into account Annexure C and D, the petitioner has been able to make out a prima facie case for grant of certain interim directions. Accordingly, till the next date, one post of Constable GD shall be kept vacant. The respondent shall bring on record their stand by filing the affidavits on or before 25th of February 2025. 26. Yes, Mr. Ing, yeah.
Can read petition number, for non-issuance of all letters, my lord, and my lord, joining instructions, my lord, like I have, my lord.
What?
For the post of my lord, sub-inspector, my lord, in the CRP. My lord, for the petitioner, even my lord, the ex-constable, my lord, in the, my lord, my lord, he was dismissed from service, my lord, on 8/2025. And appeal order also, my lord, on 23/5/2025. My lord, on due permission, my lord, petitioner appeared, my lord. The examination conducted by my lord, the SSC, my lord. And accordingly, my lord, petitioner, my lord, qualified, my lord, in the post of my lord.
You submitted a representation.
Yes.
Where is it?
My lord, representation, my lord, after the court order, my lord.
Where?
Page, my lord, 96 on my lord, 2011/2025. After issuing conditional NOC, my lord. And then, my lord, the last annexure, my lord, it is page 105, my lord. Annexure Roman 18, my lord. Twenty-eight is the last date, my lord.
What is this cutoff date business?
My lord, that is about 28/1 is the my lord, last date for my lord joining, my lord. Yeah. My lord, kindly see the annexer Roman 16, my lord, which is dated 30 December 2025, my lord, page 98. my lord. Page 98, my lord.
Yes.
Turn, my lord, the page 101. 103.3, my lord.
If you have accept the offer of appointment on the terms of concern, you should report for joining the DGP so and so on or before so and so. This has been issued to whom?
Which to the other similarly situated person who are letter for the post of service there.
It's okay, but you have not yet been issued an appointment letter. Why is the urgency of 28/1? Two?
Kindly see, my lord.
No, you have not been issued the appointment letter. That's your representation. Kindly see page 105.
My lord, initially, my lord, when for a appointment letter was issued, my lord, after qualified, my lord, on 24/10/2025. My lord, there is a, my lord, one point, my lord. Kindly see, my lord, for a moment, my lord, page 83, my lord. Page.
Where is these people? The central government?
It starts from, my lord, page 80, my lord, annexer Roman 9.
Central government? You are central government? You are central government also? They were here, na? Okay, let's issue notice, nothing there. Issue notice making it returnable on 9th of February 2026. Ms. S. Borua accepts notice on behalf of the respondent numbers 1 to 6. Extra copies of the writ petition be served upon her by tomorrow. The grievance of the petitioner herein is that the petitioner, in spite of submission of the NOC to the competent CRPF authority on 2011-2025, the offer of appointment oblique joining instructions have not been issued to the petitioner. Whereas, in respect to other similarly situated persons, such offer of appointment oblique joining instructions have been issued. Full stop. It is under such circumstances, the petitioner has also submitted a representation on 7/1/2026. And it is the case of the petitioner that the respondents may not issue the offer of appointment oblique joining instructions in spite of the fact that the petitioner was duly selected in the recruitment process. It is under such circumstances, the petitioner has therefore approached this court. The respondents are directed to apprise this court on the next date as to why the offer of appointment oblique joining instructions have not been issued. It is further observed and directed that till the next date, no coercive measures should be taken against the petitioner.
28 January is the last date, my lord.
Don't worry, let them give the appointment letter. But you give the copy to S. Borua.
My lord, 1/4, my lord, just vacate, my lord. In the meantime, if you have
Already there. It is ordered that till the next date, the respondent authority shall not take any action which would prejudice the writ petitioner in the present proceedings.
obliged.
What is this?
Lord, here, two cases, in these two cases, I filed in the petition for the modification of vacating the interim order. So Lord, the order was passed, based on, basically, based on an interim order passed by the Madurai branch of the Madras High Court. But that order subsequently was challenged before the division bench stayed that order. That is one. Secondly, there is the Madras High Court again passed another order, final order, by which the writ petition filer making the same challenge was dismissed. And my lord, they upheld the order passed by the PF authority. The matter relates to my lord, the claim of my lord, pension on higher rate. Existing rate, they were giving on higher rate. That was put to challenge. And it was the Madras High Court, my lord, has upheld the action of the order of the impugn order passed by the PF authority. And there are some other, some other petition filed in Delhi High Court. But in Delhi High Court, my lord, the no interim order was passed, my lord, the matters are pending. In the Calcutta High Court, of course, some interim order was initially passed and then finally disposed in favor of this, and an appeal is being preferred.
But Mr. Dasgupta, tell me, tomorrow, if your writ petition is dismissed, how do you take care of the situation that the court has passed directions to you that you should be paid the higher pension? Unless you give an indemnity.
But we have deposited money. 31 lakhs, 34 lakhs. We have deposited this amount. After depositing this amount, my lord, this higher pension was sanctioned. So even if the
But don't
tomorrow,
you think that a relief which was given in the interim
even if it is tomorrow, it is-
could have only been given as a final relief? See, what is the relief given? It is therefore directed that a pension at the higher rate, which was being granted to the petitioner prior to the same being discontinued
Hmm.
by the
Initially-
respondent, should be
initially it was
continued
granted.
to be paid till further orders passed by the court. Now therefore tell me, tomorrow if your petition is dismissed, who is going to bear the burden? The court?
no.
You?
Well, if you're,
Or them?
your lordship
Somebody
may,
has to
can-
bear the burden.
your lordship may only fix a date for hearing. Or it
That's-
is-
But how can this interim order be continued?
because of the fact that we have, because of the fact, my lord,
Then
every,
you give an indemnity.
because of the fact the
No, because tomorrow again, they will come up with you will come up with the thing that if you look here, Rafiq Masih is there. With Rafiq Masih out there, this particular
Well-
question comes in out here that the question does not arise. We are already pensioners and the court had directed us to pay this amount and we have taken the money, we have
the
spent. and-
interim order was passed after
What
hearing
is
the,
that going
after
to-
hearing the other side, my lord.
How do you, means it's
Well,
very
We
difficult
shall
to
file an
reconcile,
affidavit.
Mr. Khan.
If your lordship allow us to file an affidavit, definitely, or if your lordship may. fix
I'm
a date.
asking you, you are a seasoned lawyer. Tell me, how do you take care of this situation? If your case is lost, an order by which your pension was reduced.
Brother,
then
Calcutta
what
High
is
Court,
that?
Calcutta High Court allowed this petition.
Calcutta High Court is different.
Madurai High
don't
Court
you
is
go to
allowed this
Calcutta High
petition.
Court? They may be bound by those orders. I'm not bound by Calcutta High Court orders.
No.
But my question is, tomorrow, if a writ petition is dismissed, then how do you take care of it?
The pension fund.
Brother, we have already
What do you say,
deposited
Mr.
money for the.
That's why we have taken a huge amount, well, total, we have said well, about 1,30,000 crores would go out and it's a.
It is for throughout India.
Well,
It is for throughout India.
it's a corpus rate, you know. So it is, and the many, the poor pensioners may not get the pension.
কইতে দেবো না শুনলে কি করবো?
Understood. Therefore, the problem which will arise is tomorrow, how do you refund?
Brother, actually what
Give
happened?
an undertaking. Whatever amount you have received from them during the pendency of the writ petition,
No amount
on
released.
the basis of that order, you are going to return if you lose the case.
No amount released.
What?
My lord, in pursuant to the interim order, they are still not getting a higher wages.
Before that, they have got. After that, they have
They
got
said,
This order has not been complied with.
Yes.
yes.
throughout the country. So,
Not complied with, no? Oh, then it's okay. Then what is there? We'll have it after 10 years.
no, well, not there has to, because if we are, the direction is being given, that's why we're not going on to. Lordship will not. I find
both the
my
parties.
detailed affidavit
Brother,
for it.
this order was passed after hearing both the
No,
parties.
my lord, it's an instruction.
Okay, instruction. You argued the case. I argued the case.
Not to this party interim.
Inter-party order.
We'll record it that there has been no payment made in
Yes.
pursuance to this order dated 14/11, and therefore the matter requires an urgent disposal.
I'll dispose.
That's the only thing. That means it will also be there that there is no payment being made. Ah. Some cushion.
Actually, this is the relief that we want.
No, that is something has to be
Yeah.
done because
Now, my lord,
And the IOC also must also come forward with files. I appear for item number 25, Guwahati Refinery. We are paying the higher pension. So I take instruction that is how it has not been dispersed. This question which.
you are paying it to them.
No. There's a trust. That is refunded or not? There's a trust. So whether it has been refunded or not, I will take the instruction, but my query is simple, madam. If the petition is allowed, they get the areas.
They will get the areas.
They'll get
There's no problem with that. They will get the areas if the petition is allowed. But to get it, otherwise it will become a difficult thing. Tomorrow, if the petition is dismissed, it will have a far-reaching consequences.
yes, one thing your lordship may kindly bear with me, my lord. Actually, before granting,
Bearing only, yes.
before granting higher pension, all the petitioners were called upon to make deposit. Please allow me that.
Yes.
I don't understand. I know the significance.
It's okay.
And each and every petitioners has contributed more than 30 lakhs. And after depositing this amount, this higher pension was granted. So even if we lost this case, my lord, then also the amount which we have paid, that is in their purpose. Yes, so that can be adjusted from that.
Started
So
refunding.
therefore,
We have
if you-
paid more than.
No, but therefore, if they are not as of now abiding by the order passed by this court on 14/11, as you say, you are not getting the higher of the pension.
No,
So therefore,
And
we will
they are-
consider
they are-
that aspect later on and go for a final disposal.
that
matter.
can be done. Look, they are holding our money, more than 31 lakhs for each. That is with them.
Mr. Dasgupta, if it is a case where it's a private limited company, they may run away somewhere, it's a different thing. But they are an organization. Are they not a statutory organization? They will have to pay.
No, our money is with them, my lord.
Don't
About
worry.
30 lakhs.
If you have to get the money, you will get the money. But as an interim, how do you give it? Tell me.
No, in
In the
lieu of that,
interim, how do you
deposit,
get a higher amount? Very difficult.
well, lordship may kindly hear it tomorrow or day after tomorrow, any day, my lord, because we were getting 31,000 rupees per.
Tomorrow you have difficulty. Didn't you tell me about the earlier matter of 2011? Yesterday?
Oh.
So you can't help it tomorrow. Day after is Saraswati Puja. We can't have it.
Tomorrow,
Then Saturday again is on. Saturday is closed and Sunday and Monday is Republic Day. Difficult.
any lot date, your lordship convenience.
Convenience? There's no
Any day.
convenience at all.
Because our money is with them. Had this money is not deposited, we could have invested this amount, my lord. And we could have get the interest. And
Let's have it on 7th.
we,
It's a Saturday. 11th. Or
no
Mr.
problem.
A. Dasgupta, the learned senior counsel appearing on behalf of the petitioner, and Mr. P.K. Roy, the learned senior counsel who appears on behalf of the Central Provident Fund, and Mr. N. Gurwa appearing on behalf of Indian Oil. Indian Oil. IOCL Guwahati Refinery. Though orders have been passed, though an interim order has been passed on 14/11/2025. But it has been submitted that till date, the petitioners have not been paid the higher pension.
They
which the
initially-
petitioner were earlier enjoying. Taking into account the respective submissions, it is the opinion of this court that the matter requires an early disposal, taking into account that the petitioners herein are pensioners. And a delay in disposal of the matter of this kind would not be equitous. Considering the above, list this matter on 7/2/2026 at 2 p.m. Yes, what is this?
Your lordship, this is an improvement application.
Who has filed?
I have filed, your lordship.
Who are you?
Your lordship, I am one of the persons, they have challenged our gradation list. And our names are there in the gradation list. However, they have not added us as a party respondent, your lordship. And therefore, we have filed this improvement application.
We have no objection, my lord.
This is an application filed by 30 applicants to include themselves in the accompanying writ petition being WPC number 6016 oblique in the accompanying writ petition on the ground that any order passed in the said writ petition wherein the gradation list has been put to challenge would affect the applicants. The applicants herein, the counsel appearing on behalf of the petitioner, submits that the petitioner has no objection. Because taking into account the above, the applicants who are, the 30 applicants herein are impleaded, are arrayed as respondent numbers 4 to 33 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days from today. And the registry shall make necessary changes in the cause title and upload the same in the CIS. So I stands disposed, main petition. Mr. Asina, the learned counsel who appears on behalf of the newly impleaded respondent numbers 4 to 33 submits that he has copies of the writ petition available and he would like to file affidavit. Anybody? Health? I think health, sir, you have filed affidavit?
Yes, sir. The petition I have filed it.
Taking into account the above, list this matter again on 27th of February 2026.
There is also, there is,
What?
says that there is an interim order that no promotion should be given effect to for further promotion from that gradation list. Now, there are 140 posts. These are nursing council post, and they are only 14 in numbers. So I would like to file a stay vacating application.
That is, look, should I give you an
No, no.
advice? Okay. This is the matter on 27th of February 2026. In the meantime, the affidavit be filed on behalf of the respondent numbers 4 to 33 on or before 19th of February 2026. Petitioner given the liberty to file reply on or before 26th of February 2026. The interim order passed earlier shall continue till the next date. Full stop.
Deeply obliged, Your Lordship.
Yes, what is this case about?
Seeking to find a promotion of an unpaid worker to supervisor.
petitioner, madam, she joined, in Anganwadi as Anganwadi worker in 1996. And center, madam, 132, Atikau, LP school, madam. And there is a, madam, notification, madam, at page 28.
Madam, till now you have not been promoted?
No. I have already crossed my lot, when I filed this case in 2018, my lot. I have already crossed work experience for 22 years. And now also I am, 53 years old, but still, my lot, I am getting my promotion as supervisor.
You are what? Working as?
Done very well for me.
So you want to be a supervisor?
My lot, that is as per the notification of the government, my lot. That is at page 28.
Age?
28. According to this notification, madam, there is a proposal, madam, from the director social welfare, madam, to, madam, 25% reservation quota, madam.
So 25% will be promoted
Yes, madam. That too from madam.
and you have not been considered.
No,
Yes, you have not considered. Why?
My lord, the fact
She
is,
has a right to be considered, not appointed, but a right to be considered. Why? Appear in the written state held on and the result of the written state was declared on the office of the Viravasi was conducted on Iman and Iman, the result of the about the comparative summary of the at 41 in the written and Iman in the Viravasi. They could not be selected. The sales state the cutoff mark for the selected under the SC was 50. Hence the petitioner could not do. So petitioner has been considered.
considered, my lord, she did not, there was an exam, my lord, there was an written test and oral. She scored less. We have filed our affidavit, my lord, and she did not, my lord, come to that mark. She could not qualify, my lord. That is the thing, my lord. In our affidavit,
But
in para 6,
so was that a one-time measure?
my lord,
This was held in the year 2016.
16, my lord.
Okay, 2016, this happened. This is prior to filing of the writ petition.
Yes, my lord.
The writ petition was filed in the year 2018.
My lord.
What happened thereafter?
My lord, as of today, what is the status of my lord vacancy that I am not aware, my lord.
No, but
We-
have you changed your policy?
No, my lord.
So therefore, why the petitioner is still stagnating from 2018 till 2026? That's the only question.
My lord, it will be only on vacancy, my lord. My lord will take my affidavit, my lord.
Vacancy, no vacancy, but this vacancy was given in 2021.
21, my lord.
We have already crossed 5 years, isn't it? So some better sense must have prevailed upon the department to consider the case of the petitioner in the meantime.
My lord, promotion, upgradation, my lord, we did on the basis of an written and
Understood. My question is what happened after 2018?
my lord, after 2018, my lord, I'll have to, my lord, take an instruction whether how many vacancies, whether people have retired, my lord, because these are limited posts, my lord.
Mr. Dodd, this is the small submission which we are required to make at first when am I asking you? To get your instruction, what have you done post 2018 as to whether the petitioner has been further considered or not? Or whether there is any further posts available for the consideration of the case of the petitioner
Yes, ma'am.
against the 25% quota. That's all.
but it
Let the
does-
petitioner also be satisfied. Yeah, she has a right of being considered, not for appointment.
Once, my lord, she sat for the exam, my lord, under that quota. She did not qualify. Now, my lord, yes,
She
further
didn't
consideration.
Mr. Dhar, she didn't qualify in 2016.
Yes,
We are in 2026.
my lord.
Okay. left.
That instruction, my lord, yes.
My- they
The
have
petitioner herein is aggrieved.
an order of the passed by the Senate on 30th of August, my lord, 2020.
Regarding,
Regarding my lord, to take instruction and to file a.
madam, don't wait.
Taking
Don't
time.
worry, madam. Not necessary. we'll get the instructions. This court have perused the affidavit filed by the petitioner herein is agreed by the non-consideration of the case of the petitioner for promotion to the post of supervisor against the 25% quota available from the post of Anganwadi worker to the post of supervisor. The respondents have filed an affidavit that in the year 2016, the petitioner did not fare well, and accordingly, the petitioner could not be promoted to the post of supervisor. Be it as it may, the writ petition was filed in the year 2018, and 8 years have in the meantime passed by. Under such circumstances, this court, therefore, directs the respondents herein to provide instructions as to whether the petitioner was subsequently considered against the 25% quota of the Anganwadi workers to the post of supervisor, and if so, when. List this matter on 4th of February 2026 for the instructions.
My lord may indicate also that whether any vacancy position, my lord. So
That you know what to say. When I say, have you been considered or not, you can very well say.
my lord.
Tomorrow you may say that, why don't you put which vowels are to be used also? I'm fixing a comfort instructions.
I will.
Yes. List them at the D Vora standing and shall obtain whether the petitioner had deposited the amount of, yes.
I have
Yes.
received one instruction.
Have you deposited 25 lakhs?
I agree, and also undertaking is given, Lord. Already my NPS fund is also pending 80 lakhs something, Lord. Kindly adjust it.
I can't help you because you have given that undertaking. Problem, you had a good case. I know it, you have a good case, but you spoiled your case by giving an undertaking before the court that you are going to give 25 lakhs. Who has given pressure? Huh? Court has pressurized you. My goodness. Let us see which court. I think let us put it before that court, the matter, and ask the court that you have said that the court had pressurized you. Let's place this matter before that court with that thing. Huh? Mr. Counsel, you cannot help yourself because you have given an undertaking.
Just 18 lakhs 40,000 is also already pending in Department of my NPS fund.
So have you submitted a representation? Is this court the via media? Tell me.
If it can't, I can file that.
You go and submit before them. What do you want? The voluntary voluntary resignation to be accepted. That's all. What is your prayer?
I agree, Lord. But now already NPS.
Accept the resignation letter of AIA by waiving the bond condition. Anyways, this bond condition had no value. You have by yourself have come up with all these things.
It's not denied. NPS is adjusted.
Bond they let them do, but they cannot. The resignation they cannot accept or not. The acceptance of a resignation is another thing. You are asking for voluntary resignation. What resignation you are accepting?
I just transfer.
It has been submitted by Ms. D. Bora, the Learned Standing Counsel of the Health Department, that till date the petitioner have not deposited the amount of rupees 25 lakhs as stated in the affidavit filed by the petitioner on 23/9/2024. Push-up. Considering the above, comma. Push-up. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to submit a fresh representation, before the health department, seeking adjustment of certain amounts to which the petitioner is otherwise entitled to, and to pay the remaining amount. Full stop. Taking into account the above, list this matter again on 4th of May 2026. In the meantime, the petitioner is given the liberty to submit a representation before the respondent or concerned respondent authorities, seeking adjustment, said representation. Seeking adjustment if so advised. You don't have a case, you have spoiled your case. Yes.
26 next item. Dismissal of a handicapped person, lady, that was a 19, without for inquiry, without being given report. Can you please name any other death warrant, we have lost something.
Huh?
We have lots of convenience, any people should be today.
26.
27, Lordship. I think. 27.
So you want not to do it today? Let us see what is the case.
Here what the lady, we were 40% disability, I like the certificate election A. Also, was, and her son is 7% disability minor by birth. He was, what is minor, for 11 months, joined as community organizer. So that Hailakali Municipal Board. On
What is the ground on which you are challenging the termination?
party inquiry, internal inquiry without even giving me the opportunity to cross-examine and simply they give me one focus, I replied, second focus, I replied. Then Maluk, I asked for the inquiry for, social inquiry for them. They have used, that request is that the annexer K, Maluk.
Now, what is their stand in the affidavit? Oh, this is municipal board.
Yes,
Which municipal board?
Hailakali.
Who is appearing? So you were given show cause notice and finished. What else is required?
Going matter after the. Go actually temporary, but yet I.
What inquiry? Now, what additional inquiry is required? Tell me. No, you were issued a show cause, that's all.
Yes. Brought against me.
No, understood, but show cause notice has been issued to you.
Not the, then the Stoker is not issued, making allegation against me, bringing stigma against me. That rule 9 had to follow temporary, permanent employee.
How?
Yes.
No, this is a municipality.
Okay.
How do you bring the Assam discipline and appeal rules?
That will be applicable.
How?
No, let me check whether there is a provision for part.
Lordship, we have filed our affidavit also, Lordship,
Hailakandi.
for the DC, for respondent 3, Lordship, on behalf of respondent number
Who is
3.
appearing for the Hailakandi?
Lordship, somebody has to appear from both. No name is shown, Lordship. Here only the name of GA is reflected in the cause list.
Hello. Hailakandi, who is appearing? Respond number 4, somebody. I'll by respond number 4. 4 is
For
the
Lordship,
additional deputy
it's
commissioner.
DC, Lordship, the government.
Who has terminated you? Hailakandi the municipal board. Then, and why they are not appearing? Is the service complete? And what is the interim order passed? Huh?
No service. Dismissal from the service. Interim they are issued.
In the interim provided the post of honor vacated by the shall not be filled up till the next returnable date.
That was it.
That is from 2021, it is not filled up. Can't happen like this.
Didn't.
No.
Temporary service there.
This
And
is-
Lordship, the petitioner services were contractual, Lordship.
No, 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 no. Interim order till next date, returnable date. It has been not extended thereafter. Good. Why is Hailakandi not appearing? That's the problem now. Who is appearing for the government? ULB?
I'm appearing
ULB.
for
Take up with this executive officer of the Hailakandi Municipal Board.
Lordship.
Tell him if he doesn't appear on the next time, show him the video if necessary. Not appear, then we'll ask him to, we'll ask his personal appearance
Lordship.
on this
Lordship.
executive officer. Okay. List this matter and produce the records. You being the AF of the, you are paying for the ULB, na? The municipal, director of municipal board?
Yes, Lordship.
Okay, get that here. Okay, list this matter again on 18th of 12th of February 2026. Full stop. Miss So-and-so who appears on behalf of the Director of Municipal Administration. Is it a party?
Yes, Lordship.
Right,
One, respondent one.
Shall communicate with the Chief Executive Officer of the, with the Executive Officer of the Hailakandi Municipal Board. And ask the said executive officer to produce the records pertaining to the termination of the petitioner so that the same can be produced on the next date. It is observed that in the circumstance the records are not produced, the executive of this court would be constrained to seek personal appearance of the executive officer of the Hailakandi Municipal Board. On that day, we'll dismiss your case. Anyways, no more. I have to rise. One problem is I'm having with this bench. It will get sorted out after some time. I'm very slow nowadays. Yes. Yes, everybody is on the list.
Article 61.
Ah.
Regarding that program appointment, my lord, the respondent was appointed during pendency of the review petition matter. So she fixed the matter for the consideration of the interim order today. Plan is not there also.
You take a date. All of you, whoever wants, take a date, take a date as per your convenience.
Petition, my lord, hearing was taken place on last Monday. It has been refixed on 29th. So should we take up this matter on 30th? My lord?
So you have it on a date. Get the date. They will give you the dates. Because yes, get the dates and
Item 40.
if there is an interim order is there, they will extend it. Well signed.